All right. Good afternoon, everyone. Welcome to House Economic Matters. Today is Friday, February 23rd. We have 6 bills. I want to thank all the members that are here on time. With that, we're actually going to take this a little bit out of order. We will start with House Bill 272. Delegate Grammer, go ahead, sir.
Okay. Thank you, Mr. Chair, Mr. Vice Chair, members of the committee for your indulgence and the opportunity to do it first here. For the record, Delegate Robin Grammer here to present House Bill 272. House Bill 272 puts a criminal and a fine penalty on the use of straw ownership in the licenses, cannabis licenses. So over the last year, my mother received this little postcard in the mail. It said, "You too can own a cannabis license. Please call us. We'll help you work it out, and we'll make you rich." And I was very interested. I followed the trail. I brought up the online website, and it's essentially was a phishing scam that a lot of bad actors use to find equity applicants who could be straw owners. And we know this to be a problem as we've watched the cannabis market unfold. So what we're doing in bringing House Bill 272 is putting a criminal prohibition so that law enforcement can stop this activity. The problem that we're trying to fix is that there is no enforcement mechanism. There is a prohibition, a regulatory prohibition at the commission, but without this provision, law enforcement can do very little to act on this. I will say, after I dropped the bill, Andrew Garrison from the commission reached out to me, and he requested an amendment to the bill, which I have submitted to the committee via email. It really just changes the language of the bill a bit to help the commission implement it in a way that would be effective. So with that, I'll respectfully ask for a favorable on House Bill 272.
Andrew, you want to come up real quick? You're favorable with amendments, but I'll let you go ahead. Go through your brief.
Thank you. And the amendments that we have that the sponsor mentioned really help us further enforce this, allow us to also take action against the license absent or prior to or in tandem with any criminal enforcement that happens for straw ownerships. We think this is an important provision, an additional tool in the toolbox for the MCA as well as for other law enforcement capacity to make sure that the license process it maintains the integrity of the social equity applicant that you all put a lot of work into. Our office put a lot of work into making sure that this licensing round is for those social equity applicants. And of course, during that process, we already started to uncover some potential frauds that the sponsor mentioned. And we believe that this will allow us to continue to do our due diligence throughout the process as we move into the conditional license phase and then licensure itself. I'd be happy to take any questions.
So Andrew, just to clarify, as we go through this forensic audit, which is about to happen for all of them, if we find any discrepancies or anything that looks like a straw purchase, then this would apply.
Yep. So we already intend to do the forensic auditing, looking at the financials they submitted, various financial information to us. We're going to be going back and verifying that. We're going to be verifying that the individual who applied is actually the individual who would be benefiting from this. And this is really consistent with the work that we're already hoping to do.
Okay. Appreciate you and the bill sponsor. I see no questions. That concludes this bill hearing.
Thank you so much.
Thank you.
Thank you. Is anybody from the Cecil County delegation? No? All right. Delegate Miller here? Okay, hold on. All right, we have a bill sponsor. Looking good too. Oh, wow, we're bringing, man, coming in with the heavy hitters. All right, all right.
Mr. Chair, is it okay if my panel joins me?
Probably not. No, go ahead.
Thank you.
All right, so we will go to House Bill 525, Delegate Williams, or Wilkins, I'm so sorry.
Good afternoon, Mr. Chair and the esteemed Economic Matters Committee. It is an honor to be before you this afternoon. I am Delegate Janelle Wilkins. I'm pleased to present House Bill 525, Employment Discrimination, Use of Cannabis Products. The recreational use of cannabis has been legal in the state of Maryland since July 1st, 2023. And this bill seeks to safeguard Maryland workers from facing negative employment consequences due to their lawful use of cannabis. Despite legalization of cannabis, there are no employment protections in Maryland for those who legally consume cannabis outside of work. As long as an employee is not impaired on the job, they should not face any employment consequences from utilizing what is now legal in the state of Maryland in terms of cannabis. This bill specifically requires that an employer who conducts drug testing must update their policy and share it with all employees. Also, unless there is evident on-the-job employment, employers are on-the-job impairment, employers are prohibited from taking any negative employment actions against individuals for cannabis consumption during their off-work hours. Under this bill, an employer cannot hold it against an employee that has used, possessed, or were under the influence of cannabis while on the premises of the place of employment unless they were impaired. It's important to note that nothing in this bill authorizes an employee to be impaired, use, or possess cannabis during work hours. This bill does not preempt federal law requiring testing for controlled substances, and nothing in this bill requires an employer to violate any federal requirement of law. An employer can and should still prohibit possession, use, or intoxication during work hours or take action for using, possessing, or being intoxicated. This bill also does not prohibit testing for cannabis. What this bill does is that it says you have to see signs of impairment in order to take an adverse action. So I do understand that cannabis is something that our voters decided would be legal. So the purpose of this bill is to ensure that our Maryland residents are protected on the job for any legal use that takes place outside of work hours. I urge a favorable report on HB 525.
Thank you, Chairman and distinguished delegates. My name is John Gardell. I'm a fire captain with the Pittsburgh Bureau of Fire. I appreciate the opportunity to appear before you today on behalf of the International Association of Firefighters and the 340,000 men and women that we represent. I come before you today to offer my testimony and experiences on the use of cannabis by emergency services workers. In May of 2018, the city of Pittsburgh adopted a policy allowing members of the Bureau to use cannabis to treat various illnesses. This policy did bring with it some of the concerns that you have heard or will hear today. More specifically, how an employer or supervisor will handle an employee who is unfit for duty regarding the use of cannabis. Our experience over the last 5 years has shown that if we apply the same policies to cannabis that we have used for prescription medications, employees can benefit from its use and still be protected. Regarding cannabis or prescribed medication, it is ultimately the first-line supervisor's responsibility to determine an employee's fitness for duty each and every day, as they have done with other substances. Since the inception of our cannabis policy over 5 years ago, not one incident has occurred within the Bureau of Fire in the city of Pittsburgh. Cannabis, unfortunately, still suffers from a stigma associated with the years of this is drugs, this is your brain on drugs, any questions? Do not allow this stigma to prevent access to those that can benefit the most. Unfortunately, post-traumatic stress injuries, sleep disorders, chronic pain, and cancer, all of which are unfortunate hazards to a job that we have all accepted. Please help the men and women that you depend on every day to keep you safe with a favorable vote on House Bill 525.
Good afternoon, Chairman, members of the Economic Matters Committee. My name is Cleveland Horton. I do have the pleasure of serving as the Deputy Director for the Maryland Commission on Civil Rights, and I'm here to show our support for House Bill 525. You all do have our written testimony, and I just wanted to highlight a couple points. I'll have a few minutes here today. One, when we think about House Bill 525, the purpose and intent behind this bill is to add more consistency around the application and creation around policy as it pertains to cannabis in the workplace. What we've seen is inconsistent policies from employers, and through the use of House Bill 525, we are hopeful that we'll see more consistent action between employers and set guidelines for employees to understand with the recreational use of marijuana or cannabis, what that looks like in the workplace. We also hope through the use of House Bill 525 that we'll begin to eradicate the negative stigma associated with cannabis. We know that our society has evolved, and now we do have the legal use of recreational cannabis, and we believe that our policies and our employment policies in particular should also evolve in that area as well. In the area of drug testing, we know that this bill does not prohibit drug testing of any kind. This bill does lay out how to address positive drug tests and when personnel action should or should not be taken as a result of testing. In fact, this bill actually supports testing, especially in the situation where an employee appears to be impaired. And we think about the impairment burden, as individuals have indicated from an opposition standpoint. This bill does not increase the burden on employers to ensure employees are not impaired. In fact, this bill highlights the mechanisms that should already be in place by employers to determine whether an employee is impaired or not. And this bill does not expand any additional requirements or duties on employers to do so. Also, as indicated by Delegate Wilkins, this bill does not apply to federal employees or those under federal regulations. For these reasons, we do urge a favorable vote on House Bill 525. Thank you.
Afternoon, Mr. Chairman. Jeff Bodle, President of the Professional Firefighters of Maryland. Our organization represents a little over 10,000 active and retired firefighters and emergency medical services personnel from across the state of Maryland. We're here in support of this legislation today. This is something that we actually brought up at our state convention last fall of all the IFF local affiliates, which is 27 around the state of Maryland. And we all unanimously, after much discussion, decided to support this legislation. Why it's important to firefighters is cannabis is an alternative mechanism to help with some of the things that firefighters are exposed to on a regular basis. They commonly are used to help with symptoms of PTSD. It's used to help with sleep cycle disruptions that are caused by the 24-hour work shifts that we most of us work, and the constant, getting up and down and waking up multiple times, and the impact that has. And it also has been used as an effective alternative for pain management, as an alternative to some of the opiate class narcotic pain prescriptions, which tend to have really negative side effects, and they're highly addictive. And this, from a medical standpoint, has been an alternative that treats the pain management without necessarily all the side effects and things that come along with some of the other prescription medications. So this is something that is important to us, and something that I hope we can have further conversation with this committee on. And we hope to get a favorable report from the committee on this piece of legislation. Thank you.
Seeing no questions, thank you for this panel. Sorry about that, Delegate Queen.
Thank you. Thank you for the bill. Just to get some background on the legislative framework. So you mentioned that this is being used in Pittsburgh. So that's a city level. So does the state have some rules, and is this pattern after that?
As usual, ma'am, the state of Maryland is a little ahead of the Commonwealth of Pennsylvania.
Okay.
Pretty
Okay. So
normal, but Locally, we have the ability to use medical marijuana in the state of Pennsylvania. So we specifically related it as a medical procedure for our men and women to use cannabis.
Okay, so that's a state level ordinance and we're trying to take that to make it statewide, city level ordinance that we're trying to adapt statewide.
Yes, ma'am. We have a number of departments within the International Association of Firefighters, though, that have followed suit and have now stopped testing due to recreational passage within their jurisdictions, including the Fire Department of New York City, Orange County, California, and the list is just numerous.
Okay, thank you.
Fireman, thank you for your service, but are you in support of medical marijuana or both medical and recreational use?
I think it's both, only because Maryland decided to legalize the use of it. So it could be either.
Okay, but the fire department is in support of recreational marijuana, and that's okay.
I think where our interest comes in it is the benefits to be able to treat some of the things that I mentioned in my testimony.
That's healthcare. That's the health. Medical marijuana, I voted for medical marijuana. So I understand that. But what I'm saying is one of the things we do know is a side effect of marijuana can cause you judgment delay. And I'm wondering, in your profession, is that something you support?
No, so we don't advocate for members coming to the fire station to be on duty under impairment, but at least in the fire and rescue service, our supervisors are trained to recognize impairment, not only for cannabis, but for any type of impairment. And we have policies and procedures in place for supervisors to deal with employees who show up with signs of impairment from any reason.
All right. Again, thanks. Appreciate it.
Thank you. Yep.
We're all the same, right? Yeah. He's good. He's good. All right. Thank you, Mr. Chairman. I gotta be honest with you, I'm a little taken back that the firefighters as first responders would be in support of this bill. Because for one of the challenges with recreational marijuana in general, like in testing, is you can't really test when the use was. So one of the reasons why they want to get rid of testing in certain situations is because you can't tell when the individual was on it. Unlike alcohol, where there's more readily tests available, you can tell their BAC and things. And so to me, it seems like there could be a situation in which you have a first responder who could be under the influence of cannabis, who's in charge of, keeping our communities safe. There comes a responsibility with being a first responder, police officer, the other positions. Like I said, I'm a little in shock that you guys would be here in support of this bill.
Delegate, if I can respond to that, that's actually the specific purpose of the bill is what you're outlining. If in their own time, if a first responder decides to utilize cannabis, which 70% of the voters have decided, not us, but the voters decided is a legal for recreational use. If they decide to do that in their own time, to treat themselves for whatever reason it is, whether it's recreational or they feel it's for medical purposes, as long as they're not impaired on the job, we're working to protect our firefighters and our workers in their own time if they decide to utilize it. So that's actually the very purpose of the bill, is to protect that ability and protect our workers.
But the one thing in the bill, so for example, on page 2, it says in a situation in which, let's say you had a first responder test positive, this bill would prevent that fire station, I guess, from requiring an individual to retire, discriminate against them related to employment and such. So it almost seems like it's carving out some protections for an individual that could actually be in a predicament like I described.
Right. Delegate, in your own words, you mentioned, and I completely agree with you, that the test for cannabis is a test of THC in the system. That only shows that at some point in the past that someone has utilized cannabis. It does not show that someone is currently impaired at that time. So what you point out in the bill is that an employer should not be taking action for someone who is just testing positive for THC. That's a legal substance that they're utilizing. So what we're trying to focus on is impairment, is that as long as that person is not impaired on the job, that they should not be receiving an adverse employment action just because they're testing positive for THC in the system.
But that's the challenge, is that you can't really, it's difficult to tell, right? I mean, in some cases it's difficult, right? Because there's no test. I mean, so let's use alcohol, for example, and I won't belabor the point, it's Friday, it's late, but there's a pretty reliable test in most cases where you can see if somebody is under the influence at that moment. With cannabis, you can't. And so if an incident, comes up where an employee or a firefighter gets in trouble, you can't test to see whether, oh, no, it's okay because I used yesterday, so I'm good today. But like that's the challenge, and so that's why I'm a little taken back because of those challenges. That's why I would imagine most similar industries are just kind of have a blanket approach where they're like, you can't use it all because there's really no way to test, and it's not the profession for you. So.
Yeah. Thanks for your concern. And just to also clarify what Delegate Wilkins was indicating as well. When we take a look at this bill and the purpose and intent of the bill really is to protect employees from using the legal use of what we now have as legal recreational use of cannabis. If an employee is not impaired or it's not impacting their job performance, so whether they utilize the cannabis a week ago, 3 months ago, right, 2 months ago, it's not impacting their job performance. Their job performance isn't being hindered. There's no threat to the safety of themselves, other employees, or the public. So it shouldn't matter when they use the cannabis because it's not impacting in that way. And that's what the intent of the bill is, that yes, it can be in their system. And we know, to your point, that the system, the testing does not tell us when they use cannabis. The purpose of the bill is to say, if you have an employee that is impaired and you send them for testing and they do come up positive for cannabis, then you have a reason to take a personnel action against them as a result of that. Absent that, if it's just your regular great employee, you've never had any performance issues with that employee, and you happen to have a drug testing policy and they test positive for cannabis, that there should be no personnel action taken against them just because they have a legal substance in their system. That's the purpose of the bill.
Okay, thank you.
Before we go, I want to make sure I understand after hearing good delegates' questions, because we talk about impairment, and as I guess, like police officers, a lot of times, when they smell alcohol, that starts the process, right? And then they're like, hey, get a breathalyzer test. They'll do something to try and see what else there is, because sometimes it may just be, they don't know if they're sleepy or if they're drunk. And I guess my concern here is, again, because there really is no definitive way to say no threat. Well, we don't know that because they're sitting in there and we can't tell that they're high or not. And I'll say this to go one step further. So would your bill, so as an example, individual comes in, smell like marijuana, you go test them. Do you have a right to test them if they smell like marijuana?
So I would say that would be a careful, a slippery slope. And I say that because I happen to work in downtown Baltimore, right? So there's a good chance that I could go out for lunch and come back smelling like cannabis, right? I don't engage in cannabis, right? So
if I test you, you'll be fine. But if you're a smoker and I smell smoke on you, or what I think is smoke, and I test you, I don't know if you were high that day.
That's true. But
I smelled smoke and you came up positive. It sounds like it would be the same, where basically you'll be terminated because I smell weed on you and it might be in your hair from 2 days ago. All I know is, as an employee, number one, I don't want you to smell like weed at my shop. I don't want my customers smelling you, just like I wouldn't want them smelling brandy, alcohol, or brandy or tequila. And if you've come up hot because you just so happen the last 30 days to have smoked, it doesn't sound like we're really solving a problem, because they've smoked legally, but they're going to smell like it.
Mr. Chairman, from my research, and there are a lot of other states that have these policies and these protections in place that have recreational cannabis use. The usual standard is that they look for 2 signs of impairment. And that is why part of the bill is that the policy, the drug policy, would be reissued to the employees. So for in that example, if someone smells like cannabis and perhaps their eyes are red, perhaps also they're moving a little bit slower than they usually do, and you are the supervisor, that would give you the opportunity, because you are seeing signs that you believe are impairment. And in a lot of places, they usually look for at least 2 signs. Then sending them off of the job site, of course, and then sending them for a drug test would be the usual action that would take place. So I think that the premise of the bill is that we have to change how we operate here in the state of Maryland, how employers utilize and take actions against our employees who are utilizing cannabis. That means that some employers may have to get a little bit of additional training on how to judge for the signs of cannabis. They may need to work a little bit more to make sure that our employees are not being adversely impacted for doing something that we have now decided in the state of Maryland is a legal substance.
And again, I'll say that again, so that you are putting the burden on the employer. So now the employer has to step out and do a lot more. And it sounds like on every level. And I say this for a very important reason, because, and I've said before, if I own a trucking company, you're telling me I can't just say, no, nobody smokes weed, don't ever come up hot. I have to be able to recognize legally, if I don't catch it, my company gets sued. I lose my license because now the burden is no longer on my employee to not smoke. It's on me to catch them while they're intoxicated versus, and we've already discussed how difficult it is to really know if somebody's intoxicated with cannabis, but you're putting the burden on the employee. And I mean the legal burden, because as a plaintiff's attorney, if somebody hits one of my clients with a dump truck and that individual has THC in their system, I'm suing you.
So using
that's negligent entrustment.
And we do appreciate your concern, Delegate. I think one of the things, using your example with the dump trucks, right? Most dump truck drivers are also regulated by DOT, which is a federal regulation. This would not apply to them because the bill doesn't.
Example, it could be an Uber driver. It literally could be a delivery service. It could be you handling, I don't know, the fryer at McDonald's and that hot grease. And now you put the burden on me if one of my employees happens to slip and burn the heck out of somebody. Now that was my fault because I didn't catch them while they were high. And that's why I'm worried about the way the bill was written. It switches the onus, the legal onus, to the employer unwittingly. So now he has to train. Now he has to be tested, because again, there are plenty of, no offense, Pippi, dirty lawyers out there, and their whole job is going to be but I'm a plaintiff's attorney as well. My job is obviously 1, deep pockets, but 2, get to the root of it. And if you have a person on your staff that you should have known was drunk and he hit somebody, I'm getting you. So you want to apply that standard to cannabis, which is very difficult for any layman, or I would say minor expert, to understand if somebody's really high or not. And that's my concern versus them saying, you know what? My equipment's too dangerous. This job is too dangerous. Nobody smokes weed on this job. That's the concern.
I would just say respectfully, Delegate, that using the example that you give, and again, that applies to from an employer standpoint, that applies across the board, not just with cannabis. So it is an employer's responsibility to make sure their employees are not impaired.
Correct.
This bill doesn't do anything different from that. So this bill in itself says that employers should use whatever systems and mechanisms they have in place to ensure their employees are not impaired. But this bill doesn't require.
But just to be clear, but as we've said, alcohol is pretty easy for everybody. We've been around this for years. It's easy for anybody to look at somebody and tell they're a little drunk. Smell, act. Well, if it's not, you're a gifted drunk. Because for the most of us, come around Annapolis after 8:30, you'll see a lot of people that you can kind of tell right off the bat are haven't been imbibing.
Okay.
A legal substance. But I'm saying it's a different standard when it comes to cannabis, because it's much harder to tell, and there is no definitive test to say, oh, they're high. Again, Carl's looking at me like he knows better. You can spit some knowledge, but from what I've seen is when it comes to cannabis, yeah, please. Because when it comes to cannabis, you're putting the onus back on the employer to know whether this person's intoxicated. And I think that's an additional challenge for the employer. So I'll go to, I know, I'll get you, I want to go to Delegate Fennell first.
Thank you. Actually, Delegate Wilkins, she answered my question, and then also I was with the fire department for 21 and a half years. Thank you so much for answering the question. Thank you. That's it.
That was great. Delegate Adams.
Thank you, Chair. So the first question I have is, and these are mainly, these federal conversations. I mean, I'm a business owner that's regulated by OSHA, occupational safety. So my workers use saws, nail guns, heavy equipment, and the obligation. I was going to ask you who the obligation is as far as workplace safety is. What's the employer? And I would say that I have a duty that goes beyond just a casual interest in whether or not somebody's impaired to make sure that my job site is safe. People can lose their life with a saw, right? I mean, so this is not just a matter of me as an employer discriminating or violating a person's right to legally use cannabis in our state. It's that I have it's a federal obligation that's administered by our state. It's somewhat unique, but the point is, don't you see the person like me having real anguish looking at a bill saying, if I'm trying to create a safe workplace, I may end up being in violation of Maryland law that says I'm discriminating.
Delegate, this bill, because you are under federal regulations, this bill would not apply.
But it's every
It
job.
does not supersede any federal regulations. You mentioned that you're regulated by OSHA in your workplace, and so it doesn't supersede that. So whatever workplace requirements that you have, those would still apply.
So every job I do, ever since I got started in the company in 92, was OSHA regulated. I've got people that work in my office, okay, that are OSHA regulated. Workplace safety is not just a construction site. So everything I do is federally regulated, not just the saw. My warehouse has a forklift. I mean, I've got stairs. I mean, there's a safety component that you can't escape the federal part. So that's my first question. The second one is there's federal contracting laws, and federal contracting laws require me to do random drug testing. And I believe what your testimony is getting ready to say is, well, I can still do random drug tests, but if I make a mistake because I'm fearful of discriminating against somebody and I don't do what I'm supposed to do, I can lose that contract. And do you see that concern?
Delegate, everything you've mentioned sounds, and I will let others respond, everything you've mentioned sounds like federal regulations, and this law will not supersede that. So whatever practices you are following under federal regulations, you would and should continue to follow those.
All right, last question, and I'll leave this for the firefighters. This is my Class A CDL, commercial driver's license. I'll go do my test in middle March, okay? But when I go on the road, I have not just the moral obligation to not use a federally banned Schedule I narcotic. It's my obligation to be safe on the road for the citizens. So the minute that I make a decision to casually or recreationally use marijuana, and then I go on the road with one of my trucks that needs this, that is an obligation that I've violated by even asking for the Class A CDL. How does that mesh with firefighters who have these trucks on the road that have not only safety as their very first and primary goal in life, but you would want the citizens and the public to know that those trucks are being driven by people with these licenses safely.
I agree we should have firefighters that safely operate the trucks. I will note that the DOT CDL requirements do not apply to firefighters here in the Maryland. They are exempt from having to have the commercial driver's licenses here in the state. And
okay, that's fair. I didn't know that.
And more importantly, at least in the fire service, and that's the perspective I can speak from, our supervisors have training to recognize if somebody is impaired or not. They might not know what the reason is of why they're impaired, but they do have training to recognize if somebody is not acting right, if somebody seems suspicious, they consult with a second supervisor, and that person would not be allowed to operate a piece of equipment if there is any suspicion that they have any level of impairment for any reason.
But maybe it takes training, but I have no way of knowing. And on the back of every Maryland driver's license, this is not just my CDL. Driving in Maryland implies consent to chemical testing for intoxication as required by law. So even if the CDL thing doesn't apply because there's an exemption for firefighters, your firefighter and your drivers should not be advocating for recreational use of marijuana and getting on one of those trucks. That's just my Chris Adams opinion on this bill.
I think Delegate Adams covered it all, believe it or not. So did a good job. Thank you.
Thank you. I just, to the bill sponsor, I just had, a question or two, because you were you mentioned that if an employee is suspected of being impaired, the employer then sends them out for testing. My question is, where do they go for testing? And then how soon are they required to get tested and those results sent back to the employer?
Thank you for that question, Delegate. I think the intent of the bill is for them to go out and get tested immediately, utilizing whatever policy is set forth in the employer and by the employer. So the goal and intent of this bill is to ensure that employers have a drug policy that will explain the drug testing policy, what happens if your employer does send you out for testing, what is the time frame, and what is the time frame for them to get their results back. That will be kind of coordinated with whatever testing site they're utilizing and how frequently or how often they get their results back. But the intent would be, and the purpose would be, that if you are impaired and your employer notices that you're impaired at work and sends you out for testing, that testing would be done immediately that day.
Delegate, if I could just add, Maryland already has specific policies around drug testing your employees. And so this bill doesn't change how you should approach it and how the drug testing should take place. So the laws that are already on the books, which I don't have in front of me, around how drug testing must take place, those are still in play for this legislation.
Yeah, I guess I'm just more concerned about, should an employer have a suspicion that one of their employees is impaired and how soon they need to get there and how soon will those results be and where are they to go? So then what we're saying is that we're telling the employers through this piece of legislation in creating their policy that they need to spell out specifically. So are we giving them that much information that we need? I'm not an employer, so I don't know how the policies may be set up and but are we being very prescriptive to the employer saying that this is what needs to happen? This is the information that you need to give to your employees.
Yes, that's a great question. There should be an amendment, which I should have mentioned earlier, that should have been emailed to you, and it does require Department of Labor to spell out in detail for the employers under this bill how it would work and also provide technical assistance. I also uploaded in your materials an example from New York. New York has a very similar law. So again, what we're putting forth is something that is actually in place and in other states, including New York. And the example of New York's Department of Labor, what they put out to their employers in order to clarify, I uploaded in your materials, so you should have that. And Mr. Chair, if I can just make one final statement as we close out. Oh, okay.
Because I'll be honest, as everybody knows, we're not following any of New York's cannabis laws. They are a mess up there. I've seen them. They're still, I mean, it's a mess. But what I wanted to understand is, I guess I missed the beginning of this and I apologize. So what's the percentage or give me a number of how many Marylanders this year, since it's the legalization of cannabis, have been terminated or lost their jobs due to drug testing?
We have so far, we have not received any for the use of recreational cannabis.
So, and that's why I'm also worried, because here's the thing. I know employers don't have to test, and I know that we have a very low unemployment rate. And so at this point, employers get to decide whether they want to test someone, or especially for like the lower wage jobs, risk having nobody sign up. So they're allowed to set their own drug policy as they see fit. And as I said, I hear what you're saying, but I haven't heard the dramatic numbers at all of individuals who are unfairly losing their jobs, who can't qualify for these jobs. I do know federally it's not a problem because they made it very clear it's illegal. So I knowing that I just don't understand what we're trying to solve if what it sounds like is already being done. There are plenty of places like Wawa, Burger King. There are plenty of low wage employers that don't test, because if they did, they wouldn't have anybody working for them. But there are plenty of like people that don't operate under the MOSH, but they build houses. There are people that drive, heavy vehicles. There are all kinds of other companies. They themselves do test because they feel the need to protect themselves. I don't really see where the problem is if we're not getting these large influx of complaints of individuals losing their jobs.
So I'll say to that, if you don't mind, Delegate, in response to that, is that the numbers do not indicate that there's not a problem. I think early on in my testimony, one of the things I indicated that part of the intent for this bill is to increase consistency. And what we do see in the employment space is inconsistent application of policies as it pertains to cannabis. So when we think about the fact that we have not received any complaints as it pertains to recreational cannabis, that is in part to the number of employers who have, since the passing of recreational and medical cannabis, removed testing of cannabis from their policies, i.e. the state of Maryland, right? So this bill, again, the intent of it is to make it more consistent across the employment industry in terms of how we are applying testing for cannabis for employees and employers. That is the part of the intent.
Who?
For the employment industry, for employers.
They don't seem to be the ones that are confused, because again, they can do what they want to do. Who's the consistency for?
Well, I will say employers are absolutely confused. We've conducted 2 cannabis symposium. At each of those cannabis symposiums, we've had employers come and urge for this type of bill for consistency, because they have no idea what to do and how to implement policy as it pertains to cannabis. So I would say that you do have a number of employers who are trying to figure this out, to kind of figure out what they can and cannot do and how to be consistent with policy.
And we tried last year to make it very clear that there was no protection. This was not a protected class. So the policy that was there for the last 30 years was the policy that still exists. For those that are confused, I guess they weren't paying attention, because they either have a choice of whether to have a policy or go with whatever they have. So that's the policy.
Well, I think,
like you said, consistency, I don't see, this is not going to cover everyone in Maryland. We know that, especially all the federal jobs, all the construction jobs. So there will be no consistency, regardless of the goal. It will always be patchwork, depending on the type of job that is being done. And so I just don't understand if there's no jobs being lost. And again, I say consistency, but I guess if you have a guy that's applying at 40 jobs throughout the region, maybe that benefits him, but I don't see that happening. I don't really understand what the need is, because the employers that don't want to test don't have to. And you haven't told me of people dramatically losing their jobs, homes, families because cannabis. All I've heard is almost, I don't say hyperbole, but just, I'm not really sure what I'm hearing here. I see the goal, but I don't see why.
Mr. Chair, the reason why is that because cannabis is legal in our state, that we should update our laws to ensure that only those who are impaired can receive an adverse employment action. I don't see why, now that we have legalized this substance, you work to create an entire industry around how this will work. Why wouldn't we update our policies around employment to reflect that? Because someone who is on the job, who is testing positive for THC, who is doing something that we and this committee led for them to be able to do, would be fired, would receive challenges with compensation. Remember, this bill is not only about firing people, it's about different adverse employment, which we may not have data about all of those different ways that someone could face an adverse employment action due to cannabis. And so as a state, as a matter of policy, for us to expand this entire industry, but not update our employment laws to say, here are the parameters under which people can work, and here are the parameters on which employers should operate and employees should operate, I think that is a missing piece in our work on cannabis. And that's why I brought this bill. The last thing I'll say is that this is a framework on how we can update those policies. If this committee does not like this framework, I know that in your wisdom, there could be possibly other ways to do it, but I do truly believe that we need to update our employment policies when it comes to cannabis.
Got to understand. Seeing no questions. Wait, Carl's going to educate us on the weed identification. Go ahead.
Well, I just wanted to say, Mr. Chair, the popularity of cannabis hovers between 60 and 70% popularity in the state of Maryland. Right. So people are using it, right? And so a lot of times, these jobs, they drug test as a way of actually, before you get the job. And a lot of folks come up with creative ways to try to get around that, whether it's using somebody else's urine or whatever the case may be, right? So I think a bill like this, because it is a legal substance now, and people do use it, maybe we will have people more willing to go through with applying for jobs and things of that nature, because it's a legal substance, and whether or not they're using it is a determinant of whether they get the job or not.
Sure. And again, this becomes I guess, a policy decision, a difference of opinion, because right now those people choose to go to those jobs or not, that they test. If marijuana is that important to them, then those aren't the jobs that they'll go to. And I think they know that. They pick the jobs that they want and the jobs that they can fit. And I see that. I just always am very concerned with tying the hands of our employers and honestly making it more difficult for them to do what they think they need to do because they don't know if they fall federally or locally. I know it's legal, but I also know that it's very difficult to detect. It's not something unless you're trained. And again, we're talking about making people get trained when they already have a business to run, which I think is almost insane. That somehow they have to go get training and they're now responsible for this person's sobriety. And I think that putting an onus on them versus saying nobody does drugs at my shop.
But isn't that the case now? Isn't it onerous on the employer if someone is impaired?
And as we made it very clear,
that's now.
As we've made it clear, alcohol, it's very easy to tell. Versus marijuana, not so, especially if you're not a user. I know you got it. I know you figured it out. I see your eyes rolling. But for some of us who don't, I'm not gonna know if somebody's high or not. And I actually am an employer, so I won't know how to make that work, which is again why.
So I'm not an alcohol drinker.
I'm sure.
Right? So if I have a cup of alcohol, whatever the case may be, I might feel it, right? Someone who is used to drinking alcohol, such as yourself, you got a higher tolerance, right? So we wouldn't be able to tell, but you'll be able to tell with me.
Because there's a legal standard. There's literally a legal standard that's used. It's 0.08%. And it's easy to test. You can do it with a breathalyzer. We cannot do that for cannabis. So we're kind of stuck in this limbo. I believe this problem will solve itself shortly because they do have technology that's coming out that's non-invasive ways of testing. We're just waiting for it to lock down. So thank you. Thank you for the discussion with Mr. Jackson. That was great. Colleagues, thank you very much.
Thank you, Mr. Chair.
I know we'll have conversations about this. So you got my cell number. We'll be talking.
Thank you.
Calling our next panel, Bradley Klukas, Christopher Cano, Brian Hoslander, Michelle Willoughby. All right, is Joshua Fannin here? You can go ahead and step up as well, sir. Go ahead, please. Start with your name.
Thank you for your time. My name is Brad Klukas. I'm a firefighter with Howard County, Maryland, Local 2000. Cannabis has been used by people for over 2,500 years now. And it wasn't until 1936 that Harry Anslinger decided to use racism to slur the name of cannabis when he testified as the head of the Federal Department of Narcotics that minorities were using cannabis to undermine America. And all the way fast forward to 1988, scientists discovered that cannabis is actually affecting the endocannabinoid system, which is a part of every living organism other than insects, so they lose out. But that we all have this inherent system in our body that cannabinoids affect. Not the entire rest of the speech, but obviously the testing is a huge hot button. I'd like to clarify something with respect. There is actually a test that can able to test for intoxication. So in the entire nation of Canada and in many states, I'll use Colorado as a reference, they have 5 nanograms per deciliter of whole blood as their limit for DUI. And it's held up in court, and it showed that they've been able to prove with clinical studies that that is a level of evidence of intoxication. So that is a level that we can use. Also, when you're talking about federal guidelines, DOT has established oral swab fluids as a testing. And so that's the federal guideline that takes that action from, weeks away, sometimes months of a positive test of urinalysis, and narrows that all the way down to 24 to 48 hours for a positive test. So thank you for your time, and I would love to, have a little bit of discourse regarding testing.
No worries. Again, the word was non-invasive. That's the goal. Obviously, I think there's one of the states may have it where the officers can demand blood if they think that you're intoxicated. That'll never happen in Maryland.
Oral swab.
The oral swab, I was reading up on it. It doesn't seem to be as tight as you say it is, because from what I've got, it just didn't seem like something that's been wholly accepted. And again, I'm not saying the scientific community is out on it, but due to length of time that it's been used, how far back it's been used, and
I think the clarification. Do you mind if I have a little bit of time?
And you know what? Sure, because I don't think a lot of people know that. That's what I was going to get to. That there are scientific advancements that are moving it closer to where it needs to be. But go ahead, sir.
The time is going by lightning fast with the availability of cannabinoids being able to be tested on the state level. One of the things that they've clarified, and one of the things that is probably muddy when you talk about oral fluids testing, is you can either test for the THC metabolites, which is after the body processes the THC and it turns it into a metabolite, or you can actually test for the THC itself, where it would be like if you were to smoke it, it would be on your gums, it would be in your saliva, and that would show recent use between 3 to 6 hours. So the state of Maryland already doesn't have any testing levels for that, because as you noted, that it is some technology that I think people's understanding is trying to take time to catch up with. But there are states that already have these things in place. And Maryland already, in order to be charged with DUI, it's simply evidence of intoxication. And so those classes are out there. And we don't yet have any testing for people who have employment of people. Like if you were with your business, if you had somebody that was under the influence of opioids, and they had a prescription just like they did with cannabis, do you have training in how to identify under the influence of opioids or Adderall or any of the other things on the substance use policy?
Well, and again, sir, just be honest. If this was more of a tried and true methodology, as you're saying,
yes, sir,
we would have more than 264 drug recognition experts on the entirety of our police forces.
Absolutely.
So again,
sir.
I can't imagine our employers should be held to a higher standard than even our police are. Not every one of them, in fact, very few police officers who patrol our streets are qualified to actually make that arrest. And I say that because I'm a defense attorney.
Yes,
if
sir.
If you're not a DRE, good luck winning the case. But again, I appreciate your input, sir. Going to the next person.
I'll go. Christopher Cano, Director of Political and Legislative Affairs, SEIU, Local 500. So as you know, laws to overturn prohibition in this country continue to change and adapt. Workplace policy is going to need to change too. What this legislation strictly does is change how people are getting fired for a urinalysis, essentially, of THC metabolites, which they may have utilized days, weeks, even months ago. That is not an indicator of impairment. Typically, the impairment window for utilizing cannabis is about 4 to 6 hours. All right. So when we're looking at it, are we really going to allow people to have adverse employment actions for something that they may have utilized on the weekend and such? And then, when we look at the use of cannabis itself, as an adult use state, I hear the word recreational thrown around a lot, but it's frankly, it's the fact that you can utilize it as an adult 21 and up without having to engage a doctor. No different than you can go to a pharmacy and pick up Advil without a prescription. And so, again, for many of these first responders, many of the workers that utilize it, the fact that they don't want to spend hundreds of dollars to go to a doctor and get a recommendation, that they don't want to have to jump through all those hoops, and that they can just walk in easily to a dispensary and get it, utilize it for whatever that may be, whether it's chronic pain, PTSD, or whether it's anxiety. So understanding that this is about updating the existing policies. And on regards to impairment, there are existing cognitive tests, which any employer right now has available to them on the market they can utilize. There's Druid, which is a short-term memory recall test, which you can take on an iPad or PC. And there's also Alert Meter, which is a simple 90-second test, which can test for cognitive impairment. So when we talk about same-day impairment, we talk about cognitive impairment, there are tests and products out there available to the workforce. And what this is, again, this bill is all about updating existing policy, and we ask for your favorable support on it.
Thank you, sir. Mr. Kano, you're here for SEIU, right?
Yes, sir.
We know where you stand. I get that. So how many of your members have been terminated this last year because of cannabis use?
I currently do not have those exact numbers for you.
It would really be nice at some point if we actually got some legitimacy to this issue. The other, by saying these people are losing their way of life unduly. Secondly, again, when you talk about those tests, I go back to just how few police officers are trained. And we actually expect our employers of any basic craft to be more trained than police officers. So I understand what you're saying. I just think, yeah, we're really putting a hell of an onus on an employer when actually the employee can decide whether or not, one, he wants to work there, and two, he wants to imbibe, because we're still adults. But thank you.
Well, Mr. Chair, by your own example earlier, you said if you were to smell someone, then you thought they would be impaired. You know, putting them on an iPad for 90 seconds to determine their impairment of cognition, is that really an onus on an employer to have them take a 90-second test on an iPad?
If I said there's no cannabis usage, I can just send you home. Next, go ahead, sir.
Good afternoon, Mr. Chair, Mr. Vice Chair, and esteemed members of the House Economic Matters Committee. My name is Josh Fannin, and I am the president of the IEFF Local 964, representing the Baltimore Fire Officers. I'm before you today to speak in favor of House Bill 525 and thanking Delegate Wilkins for her leadership in sponsoring it. The question before this honorable committee today is actually quite simple. Is it fair and just for an employer to discipline employees for being intoxicated using a test that does not measure intoxication? That answer is no. In 2022, 70% of voters approved the ending of cannabis prohibition in the state of Maryland, allowing employers to discriminate against employees for their off-site, off-duty use of cannabis has circumvented the will of the people by tying their use to their employment. About a year ago, the state of New York grappled with the same issue and passed an almost verbatim law as the one before you today. That is a state 4 times the population of Maryland. They are home to FDNY, the largest fire department in the U.S., which is 8 times the size of our largest department in Baltimore. After 1 year, they have had 0 issues. The state of Maryland removed cannabis testing from urinalysis of their employees in November. The reason is quite simple. Urinalysis testing for cannabis is an excellent test in the world of absolute prohibition, meaning the active ingredient in cannabis should not have ever been present in your body. Therefore, metabolites that processed it out of your body should not be there either. But we do not live in that world anymore. Therefore, the urinalysis test is essentially meaningless. It detects metabolites in your body up to 75 days after use. If a breathalyzer test for alcohol were to tell us today that you had a beer on Christmas, would we consider you drunk? Of course not. If it doesn't test for impairment, it is invalid. No one wants employees intoxicated in their workplace in any capacity. That can still be addressed by use of a reasonable suspicion test. Thank you, and we ask for a favorable report.
Hello, Brian Holtzlander, Anne Arundel County Professional Firefighters, and I'd like to introduce you to one of our Maryland firefighters, Ashley Eckhart, who is seated beside me. I will try to do justice to her words. On November 4th, 2023, I suffered a significant line of duty injury. My injury required surgery. My surgeon explained it would be one of the most painful injuries to have and to recover from. He was right. Since then, I have suffered from imaginable pain, the kind of pain which had me delirious and wishing for death. I spent a week admitted to the hospital for pain management. As a result of the accident, I now suffer from post-traumatic stress. ketamine, fentanyl, morphine, Percocet, Dilaudid, oxycodone, tramadol, gabapentin, Zoloft became my way of survival. I lived weeks confined in an opiate haze with my family keeping watch to wake me if my breathing slowed. Most of these medications do not work well for me and caused awful side effects. In just 12 short weeks, I began to develop a dependency on narcotics. Addiction nearly took hold of my life. The physical process of withdrawal was one I hope to never endure again. I was desperate to seek other options. My surgeon suggested cannabis. Prior to becoming injured in my duties as a union representative, I had researched and attended training courses on cannabis used specifically for first responders. I had educated myself in the proper use of cannabis and its benefits, focusing mainly on pain management and PTSD. When I set out to become informed on the benefits of cannabis for responders, I never anticipated that I would need this treatment for myself. Regardless of my disability, my pain, my suffering, or my years-long recovery process, if I use cannabis as an alternative option, I will lose my employment. Losing your employment for seeking treatment should not be an option. Risk of opioid addiction should not be the only option. Please think of me when you think of this bill. And I will end by saying, don't forget about our firefighters. They need healthcare and they need it now.
Thank you, ma'am. And I'm sorry to hear, definitely, I mean, me saying that means nothing, of course. I don't think anybody here disagrees with the medical benefits of marijuana. I don't think anybody here wants, and I believe there are protections for individuals who use marijuana as a medicine as long as they have a cannabis card. You're saying that the medical marijuana is not protected in any of these areas.
No.
And I guess that's, again, the choice for the individual firefighter. These are specific to firefighters. All right. So you're saying utilizing medical marijuana. I don't know. Yeah, we have to look. I'm sorry, because again, there are obviously, that's something that people have a problem with. Individuals who are being terminated for use of medical marijuana. It's just, we are here discussing more broadly the entirety of the use. So I appreciate your testimony and we'll definitely look into the situation further. Is anybody else up there who needs to testify? I know we do have some questions. Go ahead, Chris.
So to the gentleman, actually, they're both in the middle, sort of address this. When we were talking about the opioid crisis, I'm in the construction industry and it's heartbreaking what is happening to our country. So when I ask the question, it's with sincerity, why do employers drug test?
It's not required by federal law. So I think it's just actually been a development of culture. Federal law requires a drug-free workplace, which I'm sure you're aware of this, but it requires a policy to not allow drugs in the workplace and not to allow the use of drugs on the work site. And that's it. The urinalysis testing came in as an easy way, almost a little bit too easy for an employer, because we did a lot of talking today about the responsibility of an employer to be able to identify somebody. If you have a reasonable, articulable suspicion policy, which means that this person has symptoms, that means that they should be evaluated for intoxication. If you just rely on a drug testing policy, on whatever the frequency of it is, you're not effectively screening your employees on a day-to-day basis. So
my opinion is we drug test because we want a safe work environment. And so when you are saying that the test that I use to make sure that I'm in a random fashion trying to create a safe work environment no longer works, it asks the next question, and it's my last one, which is, because THC is in your system for X amount of days or months or weeks or whatever, you could have taken it last night and showed up at work this morning. You could at 2 o'clock in the morning and shown up at work at 7 a.m. To work. And I don't think there's any test that I'm going to be able to do as an employer other than my observation and my good judgment as a business owner, the same that I use when somebody's drunk. I haven't had that example, but I would certainly know what that looks like. And it just comes down to some concerns I have with how quickly we did as a state legalized marijuana. So I know we're here. And now we're this year talking about some of the things that I believe many members of the House of Delegates concerned with, which is the practical application of legalizing something that's federally illegal And how do you protect people to use something that's legal in Maryland at the same time that we're in a business regulation committee? And I think the business community is saying that this is untenable. I mean, to have your testimony say that those urinalysis tests are completely irrelevant leads me to no way to, in a third party, independent way, determine whether I have a safe workplace. And I'll leave you with the last word on this because I'm assuming you'll have a point to make, and I'm willing to listen to it. But you know, the employers are listening to this bill because I'm one, and I'm shocked. But last word.
I think that an easy rebuttal to that, and I do respect it is a huge importance, especially as a career fireman, to maintain a safe workplace, and I fully support that. I want one of my coworkers coming to the job under the influence of cannabis just as bad as you want them to show up to your house when it's on fire under the influence of cannabis.
That's right.
I don't want anybody that may have to rescue me out of a house fire be under the influence of anything, in fact, be it Ambien, be it Adderall, be it codeine, be it any of the other things that are under the Controlled Substances Act that the DEA has. And the simple fact of the matter is that it's I believe, in my personal opinion, your onus to identify somebody that is incapable of performing that job, whether it's due to medication, whether it's due to illness. If you're too sick to perform the job and you have 104-degree fever, you have just as much decreased capability of performing it as you do as under the influence of a controlled substance. So I think that the point of this bill, the importance of this, is that it's not preventing me, of a firefighter who has a 250% greater chance of having cancer, of receiving the treatment that will literally save my life. I've folded the casket, or I've folded the flag that's on the casket of my brothers who have died of cancer. And that I know beyond the shadow of a doubt that cannabinoids in coordination with chemotherapy would potentially have saved their life. But the simple fact of the matter is the way that the law stands right now prevents us from getting the medicine that we deeply need. And it's not just cancer. It's PTSD, it's sleep, it's mental health, it's chronic pain that affects 70% of us. And it's so to the chairperson, with all due respect, I completely understand the fact that, you know, you don't have a long laundry list of people who have been fired from their jobs. But what's the list that shows of people that are prevented from having this as medicine? That's a humongous number.
Yep.
And to the president of the Professional Firefighters of Maryland, who just said that there's 10,000 people he represents, I can tell you that 70% of those people have chronic pain.
So thank you for that. And
Yes,
I will just add, because I wasn't before, but for every word you just said with the passion you said it, as a business owner, I could spend the next 10 minutes talking to you about how important it is to have a safe working environment.
I would love
and
to
that's
have
how
that conversation.
That's how far apart you and I are on this subject, because I think it's like a ship going across the sea and the ships are not coming together to talk. You're not hearing what we're saying as a employer. And I would like to listen more about what you use cannabis for, but that's irrelevant when I've got a OSHA, I've got a federal mandate, I've got a safe workplace that I have to create, else I could lose my business. So that's, I'll leave it there because I respect your words, but
let's have a talk.
I'm saying half of what I want to say for the sake of the committee.
And I'll say, honestly, I'm at this point, from what I've heard, and especially in the county I live in, many other counties, it's very difficult to keep and maintain firefighters. It's a tough job. A lot of people don't want to do it, especially the volunteer side. I'm utterly shocked that you guys are represented by unions, and this is not something you guys have resolved for your specific industry. I'm taken aback with this many firefighters here, and we're talking about medical marijuana, and this is not something I shouldn't have to tell a construction agency that they have to accept people that may be high because you have people that want medical marijuana cards and can't get them. Now that's its own failing. I'm very shocked. Well, I just keep seeing more and more. I said more firefighters out there. I'm like, wait, this hasn't been resolved. They need you. They want you. And you're talking about, I know we've broadened it to adult use, but we're talking about medical marijuana for people that are suffering. And this is not something your unions can lean back in on the counties for. I don't get the point. That's insane. I mean, and I mean this because we're talking literally apples and oranges right now. That's what Chris was talking about, because nobody's disagreeing with your stance. We're saying your stance should not be applied across the board. We're not saying medical marijuana is something many people would love to have access to. Most folks here voted for it. So to hear these firefighters, i.e. organized labor, not able to resolve this issue, I'm very taken aback. It's not a question, it's a point of frustration, because I don't want you to feel, if this doesn't pass, that you're going unheard. I don't understand how you've been unheard since we're so desperate for qualified firefighters, that the unions won't come together and force the counties to at least make exceptions for people with medical marijuana cards.
Do I have the opportunity to respond to that, sir?
I can't believe you'd have an answer, but go ahead.
I would love to answer that.
I mean, I
That's-
noticed that about you, but I mean, concise.
I apologize. I don't mean to try to sound like it's sword fighting. I'm just passionate about this.
Clearly, but I'm not offended.
So I think that's what we're doing here right now.
No,
I
this
think
is a statewide bill versus
Yes, sir.
you dealing with your individual unions and the rights that you have on the job. Because the thing about all these business owners, they also don't have to test. They can decide whether they want to accept medical marijuana cards or not. They can decide if they're going to make exceptions for people dying of cancer that are in hospitals. Every one of these employers can do that on their own. So can the fire departments. And I suggest they do. Thank you. Go ahead.
Thank you, Mr. Chair. So just a little bit of background, like I served in the Marines, I served in the Army, and I served in the Army National Guard, and they are three distinct branches of service. And the reason I'm saying that is because on 9/11, I was an Army National Guard member. And then on 9/12, I was essentially attached to 3rd Infantry Division out of Georgia, fully activated Title 10 under George Bush. For 24 hours after being deployed for a month, for that first 24 hours, we went directly to the impact site at the Pentagon, where we recovered remains and sensitive material. The plane went right through a skiff. National Guard members are generally state employees. And as far as a readiness is concerned, how would you answer that as far as testing, inebriation, and readiness is concerned? Because quite frankly, we live in a very, very different world than we did when I served in the Marines in the Navy.
Well, I can say that the Department of the Navy just started accepting people and making essentially what's in this bill prohibit the Navy from excluding people from enlisting with a cannabis history. So I was also served in the Marine Corps. I was also on Mighty 03.
Yeah,
So
no, 0311, there's only one job. 0311.
Only one job in the Marine Corps. So I too was standing tall on the parade deck in Camp Pendleton, California, and was deployed within a week of 9/11 from happening. So you and I shared some of the same blood at the same time.
But how does but on a state level, and they're considered state employees. And the reason I'm asking that question is because we were activated for 24 hours under Martin O'Malley. That's the only way we could go and be activated and respond right there to the impact area. So we're clearly state employees at that point. But from a readiness standpoint, and our military and our state employed, essentially military, which is an all volunteer force, how do you answer my good friend who owns a business, sort of that same vein of questioning as far as readiness and safety and on the job? And we live in a very different world than we did.
Yes,
I
sir.
mean, I was not a Hollywood Marine. I was a parasite.
I wasn't either. I was parasite. It's why I went over to the West Coast for recon school.
But seriously, how do you answer that question?
So I think that I do respect that totally. And I think that the readiness is important. I think if you're worried about short-term use and you're worried about non-invasive testing procedures, oral swab testing for THC or THC metabolites takes that window and narrows it all the way down to a very short time period. But also I think it's important to note that in the same readiness, you're not daily, testing your employees to making sure that they're not under the influence. This bill specifically addresses the urinalysis being able to be used in random drug testing. So random drug testing doesn't prohibit people from doing it every day when they show up to work. It just shows that they did it at some point in time.
Thank you.
Yes, sir. And Semper Fi.
Semper Fi.
Everyone can speak. Yeah, thank you. I believe that covers everyone on this panel. Next panel, we have Shaneth Lewis, Ashana Kesh, the rest of the favors are virtual. Again, Ms. Lewis, Ms. Kess. Go ahead, please.
Good afternoon. My name is Shanitha Lewis. I want to thank you all for having me here today. I am an Army veteran. I have served in OIF and OEF. I was also in the Army on 9/11. I deployed 2 weeks later. I was out at a nightclub when we got called up and I had to wait. I sobered up and then that next morning I had duty. That's the same thing you would do with cannabis. I had a lot of very poignant things to say, but now that I've heard all of the committee's comments, there's a few things I want to point out. If I had an opioid prescription, I could take my tank and run it down around this whole circle. And as long as I turned in the prescription, I would not be impaired. Being fit for duty and being impaired and using a urinal analysis are two different things. I also graduated at the top of my class in the top 3%. I grew up in West Virginia and I had a terrible, terrible education. I deserve more than a job at McDonald's. If I want it, I should not have to take a urine analysis in order to get that job. And having my rights taken away from something that I'm doing lawfully when I am off duty is wrong. And that's why there should be a law that prohibits people from doing that. The onus is already on the employer. That's why you're the boss. The onus is on you to see if people are impaired, whether that's at war, whether that's at McDonald's, or whether that's when you're driving a truck. And you taking a urine analysis does not prove impairment. It does not prove whether someone is fit for duty. Economic health and employment health. Economic health and being employed is good for your mental health. I have PTSD and cannabis saves my life every day. It's that important to me. Thank you, and I urge your support for HB 055. Thank you for your support. Thank you. My name is Nashana Kess. I'm the Executive Director of the Maryland NAACP, and I'm coming to you in favor of House Bill 525, which is vital for communities of color and the working class who have suffered from unfair employment practices, especially for nonviolent drug offenses like cannabis. The war on drugs has disproportionately harmed these communities, leading to mass incarceration and economic struggles. The bill is a significant step towards rectifying these injustices by protecting workers, more than just the ones at Wawa, who use cannabis outside of their work hours or for medicinal purposes or in their personal time outside of work hours. It's crucial in the context of cannabis legalization, which has often left communities of color behind while predominantly white-owned businesses have profited. House Bill 525 isn't just about employment rights. It's about racial and economic justice. It aims to ensure fair treatment for individuals in the workplace, regardless of their cannabis use, and breaks down barriers for marginalized communities. Regardless, under the legal doctrine of respondeat superior, the employer is responsible for the negligent acts of their employee, which means they already have a duty to ensure an employee is not impaired. Wouldn't it be easier to address when you have a policy that directly impacts intoxication at work, limiting while they are protecting the rights of the employee outside of work? By endorsing HB 525, Maryland can begin to dismantle the cycle of discrimination and inequality that has plagued the Black community and the working class for far too long. Thank you for considering the impact of this crucial legislation.
And thank you both for presenting. I don't see any questions. I would ask, so when we talk about not testing, we're also talking about for crystal meth, for heroin, for opioids for we don't want to test anybody for any drug. Is that where we're going?
I believe that people should be tested for impairment.
I got you. That's what I'm asking.
If you're testing for, if we're talking about illegal drugs, of course not. But at the same time, I keep wanting to stress that opioids are very legal. You can't smell them. There's no breathalyzer for them. And you can be nodding out at your desk at work or behind the wheel of a car. And as long as I present that prescription, then unless I was told I was impaired by a police officer, then I wouldn't be called impaired. But with cannabis, you can take my urine and say I was impaired at the job.
But also for cocaine.
Cocaine is illegal. That's an illegal. I'm talking about that legal substance.
No, I'm saying, but they can't test if you're. The way the bill is, it's not specific to cannabis, to my understanding.
No, it is specific to cannabis.
But if you can't do your analysis,
well,
how does that work?
As the previous presenters had brought up, there are swabs. The Chesapeake.
No, I meant they're doing the getting rid of the random urinalysis is what I'm talking about. Then how do you test for the other drugs?
I don't think that you should get rid of the urine analysis. I think cannabis should be removed.
That's the only thing I was trying to narrow the tailor. I want to get your point on that. Thank you very much.
Yeah, I don't think any of this said that you could not test. What we're stating is that there should not be an impairment while working, but these employees should not be penalized because they're using it while they're not working. And that's what's happening right now.
You don't mind random urinalysis. You just don't want them to be penalized if it's marijuana that comes up on their system, correct?
There's levels of THC, which was described earlier, that can tell.
I know, I literally built this system to make sure that African Americans participated at an outstanding rate and actually got the money for the past things that wrongdoing. So I do understand cannabis. I understand that last. I just want to clarify, you guys are not against your analysis. You're just against if it comes back hot, if they come back hot for marijuana, you don't think that's fair because it could last up to 30, 50, 60 days, correct?
If the test shows that they were using within the time frame that they were at work, then they should be penalized. But if the test shows that they were using, there's likelihood that they were using outside those.
You're just talking about marijuana, correct?
Yes.
Correct.
Thank you. Everybody on? Let's start with this. Yep. Ms. Noggle, you can go first.
Thank you, Mr. Chairman, members of the committee. My name is Olivia Noggle. I'm the Senior Policy Analyst at the Marijuana Policy Project, or MPP. We are a national nonprofit, and we've been working to reform cannabis laws across the country over the last few decades. I'm here today in support of HB 525. I've submitted written testimony as well, and many of the points that I've wanted to raise have been covered by others, so I'll be brief and just say that, other states that have legalized cannabis for adults are increasingly taking this step to ensure that workers don't lose their jobs for using cannabis outside of work hours. In fact, 9 of the now 24 legalization states do have some employment protections for adult use cannabis consumers, and Maryland should follow suit by passing HB 525 this year. I'd like to thank Delegate Wilkins for her leadership on this important issue, and I respectfully urge a favorable report. Thank you.
Go ahead, Paul.
Yes, my name is Paul Armentano. I'm a Maryland resident who has worked professionally in the field of cannabis policy for nearly 30 years. I'm currently the Deputy Director of NORML, the National Organization for Reform of Marijuana Laws. And during my career, I've testified as an expert witness in numerous state and federal court cases specific to issues involving cannabis, drug testing, and impairment. In fact, all the issues that have come up from speakers and from the lawmakers over the last 2 hours, I have dealt with in court. I'm testifying today in favor of House Bill 525. I submitted written remarks, so I'm going to use my last minute and a half to address some of the questions that have been raised over this course of this hearing. It was asked what other states have enacted policies similar to this bill. Several states have. California, Connecticut, Minnesota, Montana, New Jersey, New York, Rhode Island, and the District of Columbia have all enacted workplace protections similar to this bill. It's been asked numerous times, how can we actually test for marijuana impairment? As one of the speakers said earlier, there are several cognitive performance tests available on the market for use in the workplace that do test cognitive performance for impairment. Alert Meter is one, Druid is one. Druid has been substantiated in numerous peer-reviewed studies as being able to identify people under the influence of cannabis at that time. The final thing I'll say is so much has been made in these remarks as conflated the idea of detecting a substance with impairment from that substance. Urinalysis is simply a detection test. It detects a non-impairing inert metabolite and detects carboxy-THC. That only exists after THC, the actual active ingredient in cannabis, has been converted and is no longer active. It's actually a non-impairment test. I'm happy to answer any questions folks may have.
Thank you very much, sir. Doctor, go ahead.
I've been asked to provide testimony. I'm a professor at Johns Hopkins, but I'm not representing Hopkins in any way, shape, or form. So I do controlled cannabis dosing experiments at the laboratory here and have a lot of experience looking at drug testing outcomes. I can report that there is no current drug testing method, urine, saliva, or blood that can differentiate reliably whether someone's impaired or not as a result of using cannabis. We need to push forward towards looking at impairment in workplace based on behavioral testing rather than biomarker testing. It's important to note also that people can test positive for THC after using federally legal hemp products. And I've testified in court cases for law enforcement and other public servants who've used legal hemp products or been passively exposed to cannabis smoke. And these are environments where it's, again, legal now. So recognizing that detecting impairment in the workplace is most important and that biological markers of testing is insufficient, I think we need to rethink how we approach this. I think that penalizing or preventing people from seeking employment from using a legal substance is not the right way to go. We have examples of medical use of opioids and benzodiazepines and other medications that can cause impairment are not fallen under the same umbrella. Same way alcohol for non-medicinal use is not preventing anybody from employment. I think we can use that same approach to cannabis to keep a workplace safe and not unduly prevent people from getting or maintaining employment.
Thank you very much, Doctor. Nope. Seeing none. Thank you very much, panel. Again, seeing no questions, and thank you for your testimony. We're going to now move on to the unfavorables. We have Louis Campion, Jeffrey Ferguson, Andrew Griffin, Michael Halloran, and Matthew Pipkin.
Good afternoon, Mr. Chairman, members of the House Economic Matters Committee. For the record, my name is Mike O'Halloran here today on behalf of NFIB in Maryland. You have my written testimony. It's been a long afternoon. You have a while to go, so I'll just cut right to the chase. You look at the two sections that I referenced in my written testimony, if you're keeping score at home, and in speaking more broadly, the way this bill is constructed and laid out, it frankly, taken together, it creates an unworkable framework for small businesses to create and enforce an effective drug policy at their place of business, a drug policy that works for them, their employees, their customers, and their clients. There's been a lot of discussion today about employees that want to pursue a certain career or a certain job, but the drug policy at that employer's business may not fit with their want or their need, perhaps, to use cannabis. Look, I think these are very interesting questions, very difficult questions. Honestly, it boils down to whether or not you believe an employer has the duty and, in fact, the right to protect those customers and employees, or you feel that an employee should be allowed to use cannabis or frankly, any other intoxicant substance whenever they want and still be allowed to go to work without fear of any adverse action. Because, the proponents will say, no, we're just looking for a framework. And we are here, I think everyone at this table is going to tell you pretty much the same thing. The way this bill is constructed, it makes that an impossibility for an employer. So with that, we respectfully request an unfavorable committee report. Thank you.
And Mike,
Sir.
we have a relationship. So I have a few questions I need to ask you. So
Sure.
first of all, right, and we've heard a lot of testimony today, and we're talking about, basically right now, there's not a lot of people losing their jobs. The unemployment rate is low, but that could change.
Sure.
And so what I want you to explain to me is it's a legal substance.
Mhm.
And you've heard now that the testing is somewhat loose. So how do your clients deal with somebody who they suspect of alcohol impairment?
There was a judge long ago and the question was surrounding pornography, right? And it was trying to define
what we see.
And
Come on, bro.
the response was, I don't know how to define it, but I know what I
Okay,
see.
so
It's the same sort of thing.
So that's my point.
Yeah.
And again, beg to differ depending on how much you drink or don't, that you may not be able to recognize it. So I guess what the people are saying is we made this legal.
Correct.
And the current testing that is utilized is urine. And that testing by all accounts is antiquated. So what I'm trying to get to is you have individuals, and right now it may not be an issue. I asked for numbers, there may not be, but that doesn't mean there won't be.
Correct.
So now that we've made this legal, and believe me, I'm not trying to create a protected class of pot smoker, but I am trying to protect the rights of employees as well as employers. And currently having a standard of if you've smoked in the last 30 days, I can fire you, seems troubling because it's now legal and there's no way of telling if that was recreational or not. In addition, one of the most troubling things was the whole medical marijuana side, that there's not even a standard for individuals. And I know I've got plenty of buddies out, they just got their medical marijuana card because they could, but there is no standard or drug policy for that pain management. And as you heard, if you test me for opioids, if I have a valid prescription, I'm good. Why didn't that work for marijuana? It's some would say a better pain management drug than opioids.
Sure. Well, I think, it's very tough because given this substance, given cannabis, right? The testing technology that we have right now, and I know there's some discussion, well, there's this test and there's that test, but at the end of the day, I think we all would agree that the test is imperfect. It's not as useful as, let's say, the testing that we have for alcohol. So to your point is, the testing that we have right now for cannabis, and as an employer, I can't tell if you used last night or you used 30 days ago. So the fear with this particular legislation is that, in a manner of speaking, we're putting the cart before the horse, that, we don't want to pass this bill too early and too soon before we really, quite frankly, here in the state of Maryland, for all intents and purposes, the ink just dried on legalizing cannabis 13, 14 months ago.
So I got you. But let's be honest. You've already heard from other people that there are cognitive tests, and apparently they're simple enough to use on an iPad. Depending on your age, how simple that may be. But what I'm saying is they're trying to explain that there is a difference between impairment and recreational usage. Why should they be punished? So what I'm trying to get you to understand is, regardless of what you think, something's coming.
Sure.
Because it has to. When you have these people suffering from medical issues, and I can fire you for smoking marijuana, but it's okay for you to use opioids, I find that troubling. So I'm just trying to get you. So my point is this: since this is not what you would consider a good framework, why don't you give me one? Why don't you give me something that's going to protect small businesses, but allow individuals some recreational use? Now, I'll say for the firefighters, there's county things going on there. Y'all need to get with your unions. That needs to be fixed. That is not, I don't know how to even begin to approach that. But when it comes to the small businesses, then maybe that's part of your job. You get me a framework, because at the end of the day, I don't find it comforting that people were turned back to opioids because they would get fired for using marijuana. Period. Or I don't find it comforting that at the end of the day, they would go ahead and say, well, I don't know when you use it so on the safe side, I'm going to fire you. Versus, hey, you've come up hot and look how many times I've had to correct you for this action. Or you smelled like a standard where people would know you smell like marijuana these 8 days or these 3 days. I've sent you home. Something more than, hey, you know what? The best thing we can do right now is nothing, because it's not true. Y'all hippies voted for this. It is now legal. I set a standard out to make sure it's accessible and it's safe, it's affordable, and African Americans and minorities will be able to participate in the system. But what I expect is from you and your people to now give us a standard. We can't say it's okay to use, but then say, guess what? If I catch you, I'm still gonna punish you.
Sure.
So, and that's what it seems. And what you're telling me is, no, just wait another year. And again, I know they don't have any statistics for me, but they will. And I'd rather not be wrong now to screw people up later. So I understand I'm not, and I mean this, and the bill sponsors over there, she hears it. I'm not trying to create a protected class of people because I already am one. 2, I am not trying to create a boutique area for law firms to get into, because I see that too. But I guarantee you we can do better than what you're saying. I guarantee you we can do something more. So everybody else, I'm letting you know before you testify.
Sure.
I'm expecting something more. You can say no, but I promise you, I'm not going to sit here year after year and hearing people tell me about their lives and how some of them have to go back to heroin, or guess what? They just used it 20 days ago.
Sure.
Because y'all voted for it. It's unacceptable to say right now, this is as good as we got. So guess what? That's unacceptable.
And Mr. Chairman, you are absolutely right. And I think, set me aside, but I think the organization that I represent well enough that one of their bedrock principles is, listen, this is my business. I've put my hard-earned money into this business. And to a certain degree, obviously within limits, is I'm going to do the best. I'm going to try and do the best that I can for my company, which also includes my employees. That being said, they also believe that if there is an issue, whatever that issue may be, whether it's how much you are paid, what position, what promotion you're given, or what you do on your free time, we always advocate that that is best left to an employee and an employer to have that discussion. If you know that your employer has, by and large, a zero tolerance drug policy, and you want to partake in recreational cannabis because it's legal, then one of our responses will be, let's let that employer and that employee hash it out.
Well, then how many of your people you represent have a zero tolerance alcohol policy?
I don't have the numbers, but I would imagine it's quite a few.
They say you should never drink alcohol.
Oh, I'm saying no. I'm saying on the job. You should not be on the job.
You mean impaired, right?
I'm sorry?
You mean be impaired by alcohol?
Correct.
Because I can assume we all have that, and that's what they're saying. They're not saying I'm gonna follow you home on the weekends like you should do, because that's when you might drink, right?
Sure.
They're saying it's not fair to hold me something accountable if I did on a Saturday when it's Monday.
Sure.
And I'm saying right now to say, well, tests don't do well enough, I guess we're stuck. It's unacceptable, because unless you can start following them home or make them sign an agreement that they will never drink, which you're not, you should not basically say that for cannabis, because that's what you're doing. You don't make anybody, none of your employers make somebody go, you better agree to never drink. And I mean never. Don't let me catch you at a bar.
Sure.
It's a legal substance. Do what you do. So why are they allowed to do that for cannabis?
I understand, and I lean on my original, and these are all valid points, Mr. Chairman, and I lean on my original statement, which is, frankly, look, the testing, and I know we're kind of going back and forth in a circle here, but the testing right now for this particular product, we are, I think, just stuck.
Then why not go to impairment? No, and that's what I'm saying.
Sure.
How are we stuck when the only way that you fire somebody for drinking is if you smelt it and they were acting funny? Fair?
Yeah, and that's
so. Why would that not be the same standard you would apply to cannabis?
I think it should. I think we are saying that it should be the same standard.
So you're agreeing with parts of this bill that it should only be impairment, and that you should not. They shouldn't. If they come up hot on a piss test, that they shouldn't automatically be fired. Is that what you're saying?
No. Actually, if you look at my written testimony, I'll read right.
I didn't, but you can tell me now.
Okay, so I think a lot of what's in this bill is consistent with some of the drug policies that employers
But you
currently
came in unfavorable,
employ. That's correct.
not
because-
favorable with amendments.
Correct.
So what I want you to go back, tell me why it shouldn't be a standard that you smell like weed, you're acting funny, you gotta go. Because that's what let me ask you a different question. If one of your members, somebody came in, they were slurring their words and they smelled like whiskey, do you still test them? No, you fire them. You say by my layman's eyes, you were drunk. I don't like people drunk. So why couldn't that be a standard in employment? And mind you, I'm thinking on my feet here, so I would expect more from you. This is what you do. Why would that not be a standard? Oh, you can fire somebody, especially in Maryland, because guess what we could do anyway? I ain't got to tell you no reason. I can just fire you. What they're simply saying is, don't make me take a urinalysis for cannabis. Catch me slipping. Because that's the only way you can fire somebody for alcohol. Please tell me why that wouldn't be fair.
I don't think anybody's arguing that wouldn't be fair.
You came in unfavorable though.
That is true. And going back to my statement that, look, the policy that's laid out in the House Bill 525, the policy that they're trying to create does not, parts of it do work for employers, but overall, the way it's constructed and the way it's written.
Brother, that's why we're having this conversation.
Sure.
I don't agree with creating a protected class, but I do agree with protecting legal situations and legal acts. I need this to work.
Sure.
I can't keep villainizing it because then if it stays black market looking, then it continues to be dominated by the black market. We've shined a light on it. So what I'm expecting from you is something more than a no. If you don't think this framework works, well, then you got to give me something that explains how intoxication isn't enough in cannabis cases, but it's okay for alcohol. I would like to know that. I'm not going to put you to that now, but I know you know where I work. So I expect something soon.
You got it.
Who's next?
Mr. Chairman, Andrew Griffin here on behalf of the Maryland Chamber of Commerce in opposition. So I heard two things. I heard we want employers to rely on impairment. I just heard the gentleman from Johns Hopkins testify that there's no reliable way to identify impairment. This bill makes it so that if an employer has a policy that you act in a certain way, I say, you are high today, go home. And they say, no, I'm not. It's a he said, she said, if I send you home anyway, because I can't test you per the bill unless I have pre-qualified that testing with observing articulable symptoms, which every employer, I suppose, is going to be qualified to identify those. Unless I've observed those, I can't send you home. I can't fire you. I can't move you from you're not going to work on the line today, you're going to stack boxes, because that is a violation of the whatever the definition in the bill is, and therefore the employer is open to a discrimination suit. Now, I don't believe that exists for alcohol, Mr. Chair, because if you smell like alcohol and the employee says, I'm not drunk, you can say, well, I can send you to be tested. And that test is significantly more accurate. And it comes back and says, yes, you are drunk, or yes, you're not. The employee can't then sue you for a discrimination complaint. So to the point just made, I understand your point, Mr. Chairman, but also the point made, you're asking every employer, the 20-year-old manager at the t-shirt shop on Main Street, to be able to be trained to recognize active impairment because the drug policy may be XYZ. And if they send them home, that employee is open up to a discrimination suit. So I believe you that the technology is forthcoming. I think that is a major shortcoming of the bill. It just says testing positive for cannabinoids. It doesn't identify the urinalysis test. If in a year we have an accurate breathalyzer, fantastic. Employers will embrace it and be able to use it.
First of all, the doctor did not say you couldn't identify impairment. He said you couldn't properly test impairment. He gave several, and he went on to talk about cognitive tests.
The iPad.
So you can legitimately identify impairment. That's not the problem. And I guess that was the point he was making is, well, there may be some cognitive tests that you could give an employee to say, all right, now you failed this test. Like, police officers complain all the time about, oh, somehow I legalized weed when I didn't. she knows who I'm talking to over there did. But at the end of the day, they're upset because now they don't know how to deal with individuals that are driving while high. And I said, well, you learn, figure it out because it's not that hard. And they'll tell you it's not. There's the glassy eyed. What's the main one? The flashlight in the pupils, guys. Come on. Literally, you know what happens. They don't dilate. They stay real or they stay real wide. I know that. No matter how bright the light is. I went to high school and college.
I plead the fifth, sir.
Right. So we all know that there are something, and you go, with that and the way you smell, because now we're talking about active impairment. And I don't want to keep skirting the issue to say somehow impairment is not important. And that somehow this 20-year-old, by the way, who probably be able to identify somebody high way better than you or I could.
You're probably
let's be
right.
honest, especially at a t-shirt shop. But that there's somehow some way that they couldn't have that they suspect something. Now, I'm not trying to make a protected class. It almost offends me that this is called discrimination because you don't have that for alcohol. We don't discriminate against somebody, no, that's not a protected class. Like you said, I smell you, you're drunk, you got to go. But I do believe you guys need to really start looking at, number one, impairment, two, for individuals with medical issues, because not only is it now legal, it's also accepted medical technology. It's got to be something better, guys. It's got to be something better.
Mr. Chairman, I will just respond to the medical component and forgive me, the sessions run together, but I believe this body did pass certainly protection in hiring in the employment phase for those with medical cards. And I believe there is something, and that was either within the last session or two. There was also potential discussion about, and I think it went through judiciary and JPR, if I remember correctly. It did not come through this committee, and specifically dealing with hiring for those holding medical cards. And there is also, there have been some bills dealing with treating those with men. I can't remember if any of them have passed, treating those that hold medical cards, asking employers to make accommodations as if they were to have a disability. And so we've seen those in the past.
I don't know what those laws are. We'll find out because I'm not leaving this session without a better solution than doing nothing. Go ahead, sir.
Good afternoon, Mr. Chair, members of the Economic Matters Committee. My name is Matt Pipkin. I am here representing the Maryland Multi-Housing Association. It has been a long hearing. You have my written testimony as submitted. I will concur with earlier the chair's concerns with the legislation, and I concur with my members up here. I'm happy to take any questions. Thank you.
Great presentation, sir. Go ahead.
Good afternoon, Mr. Chairman, Vice Chairman, members of the Economic Matters Committee. I'm a passionate business owner myself, Jeff Ferguson, president of Ferguson Trenching Company and FTC Aggregate Supply, that are family-owned businesses. We have offices in Odenton, White Plains, and Forest Hill. A lot has been said this afternoon. Our businesses specialize in underground utilities, such as water, sewer, storm drains, and I work for the power companies as well. Safety is huge. We've had drug policies since 1988. My company is actually involved in 3 different drug programs. 2 are federal, and the third one is what I would call corporate. It catches everybody else in my company who is not under a federal drug program. I'm not sure anyone truly understands the impact of the use of cannabis, but our main concern is there is no way to be able to test for being under the influence or intoxication. Page 7 of the bill states, unless the employer has established by a preponderance of the evidence that an unlawful use of cannabis has impaired an individual. I think there's been a lot of testimony here today that is pretty much impossible for an employer to be able to prove. The bill, in my opinion, is the beginning of the employers losing their rights to be able to drug test for the use of cannabis. If this bill were to pass, I do believe it would make job sites less safe. In closing, I'm asking the committee to help protect the worker safety and vote unfavorably for House Bill 525. Thank you.
Mr. Ferguson, I wanted to ask you, and I'm glad because I don't believe even the bleedingest heart of hippie would think that it's okay for people on a work site to be high. And I think that I would ask that would you treat somebody on a work site different than I would think you'd be more concerned about somebody operating a forklift or a dump truck or a backhoe a little different than you would your secretary. Like different jobs, I believe even in this, there could be exceptions for when testing would be okay. to ensure, because like you said, if you got a huge work site, you can't run around to everybody. And we all know how dangerous it is to be operating while you're drunk or high. And again, we're getting into that whole intoxication thing and who's responsible to know, because you don't want anybody operating a backhoe while they're drunk either.
Correct.
But we do know it may be a little easier to learn, you understand if they're drunk or not. My point is, there obviously would be exceptions to the rule when it comes to stuff like this, certain jobs and occupations that we would definitely say should be tested to make sure, for the safety of all, that lives aren't lost. And it sounds like that's what you were here for, because the work sites that you deal with, correct?
Correct.
Okay, sir. Thank you very much. And I appreciate your testimony.
Thank you.
Go ahead, Chris.
Thank you, Chair. So Andrew, you nailed it. There is no discrimination standard where somebody works for me and they're intoxicated and I say, you're fired. If I'm wrong, they're not intoxicated. I mean, we're an at-will state. Okay. So that's a standard that I'm thinking, as I'm hearing you talk about this, we're trying to apply a different standard under this cannabis. Is that your testimony?
Yes.
Okay. Because the real world, no, go ahead. I didn't.
Yes.
So the real world standard here is not whether or not I'm looking around, trying to look around somebody's shoulder to see whether they're drunk or whether they're high. What happens is workers mess up. And a secretary who handles my bookkeeping, who may relate to having tax filings, can screw up high and cause me a great deal of pain as a company. I have a right and obligation to protect myself in that job the same way I would with somebody who's running a power saw and can cut their hand off. And so I'm not necessarily thinking there's different classes of workers. I think there are workers that work for me or they don't work for me. And I have an obligation to run a business, a private business, in a way that best suits me without discriminating on reasonable standards that we would all make sure you would never want me to discriminate on. Right? But what happens, and this is the question, Mike, I'll ask you. Let's say I'm in the business of floor covering. Okay.
That's a stretch, but
okay.
I'm following.
All right. So I get a call from a customer and the customer says, I just need you to know that one of your employees is out in their truck smoking dope. And I don't like it. What are you going to do about it? Well, Mike, what do I do about it? Well, no, wait, what do I do about it if this bill passes?
If this bill passes, if I were you, I wouldn't do a thing, because I'm not going to risk being hauled into court or having a complaint or go through an employment discrimination process based on the facts as you just laid it out. Without this bill, totally different story. I would feel a little less, I would feel a little bit better about looking into the situation as opposed to with this law on the books. I'm sorry, ma'am. I guess I lost you as a customer.
So Andrew, I'm going to ask you another question. In that same scenario, I got a customer that calls me and says, Chris, you've got one of your workers in their van drinking Tito's vodka. And then I fire them with this bill in place. That person I could fire and I wouldn't be held in a discrimination setting.
That's correct. Correct.
That's why this bill is unworkable, Mike.
Correct.
To your point, is because we're talking about theoretical. You think I'm going around randomly drug testing people 2 or 3 times a month. That's not the case. Most of this comes down to worker performance and analyzing what the heck's going on in my job site. That's my job. And that's not discrimination if I'm trying to protect myself, protect my finances, protect my customers, and most importantly, and to the real crux of this matter, having a safe work environment. Isn't that so?
That is so. Yes, sir.
Everything he just said, but your customer has a federal subcontractor or you're working on federal property. Everything he just said, but you have employees working a federal subcontractor to the, I'm a federal subcontractor right now.
You should be exempted under the bill.
Okay.
The bill does address that.
Okay. What if you're working on, but I mean.
For pre-screening employees and for testing.
For testing.
So you wouldn't have to pre-qualify the testing with observing someone's symptoms.
But what about on the work? What about on the work site? That's what he just said, smoking dope in the van.
So technically, theoretically, to have a federal contract, you have to agree to a drug-free workplace, a zero tolerance policy.
How
So
do
you
you-
would pre-screen your employees, period. You would be required by federal law to test them.
But, so there was an accusation made. Like my.
If there
friend
was an
just said.
accusation made, you would be required by federal law to test them.
Thank you very
The
much.
urinalysis test.
Okay, thank you.
Thank you, Mr. Chair. So the chair actually asked several questions that I had, but let me ask a follow-up. Mike, have you ever been called a hippie before?
No, ma'am. I've been called many, many things. Some maybe by committee members behind closed doors, but never a hippie. No, ma'am.
So in all seriousness.
Yes, ma'am.
I'm trying to understand what happens, this question of impairment. First, I did want to clarify, because I do want to make sure that we're all on the same page. What we've heard from multiple people is not that there aren't tests for impairment, it's that there's not biomarker tests for current impairment from cannabis. So I guess my question is, how do you currently test? So are we in agreement on that? That there
Yes,
are
the cognitive tests,
impairment
yes,
tests
yes.
that are reliable. That's what the doctor said. So I think my question is, right now with opioids, if somebody has a prescription, they could have a prescription, they could be impaired. That impairment could create danger on the in the workplace. So how is that test conducted? And let's start there. Why don't you tell me that?
I would just say so like alcohol. If on the job, someone is impaired by, let's say, a narcotic that they have a legal prescription for, the employer reserves the right to, let's say, move their position. Again, as an example, maybe they're working on a manufacturing line. You seem impaired to me. I'm going to move you over to this position where, you're not in danger of getting hurt.
Okay, so but how do they know that? Like, how do they know?
They're
that someone's
observing. They're observing. The issue becomes then if the employee says, no, I'm not impaired.
impaired? And how does that work right now for opioids?
The employer could order a test, a biomarker test, a urinalysis test, I believe. You're looking at me as if I'm wrong, but I'm pretty sure.
I'm asking. I'm trying to.
You're just on this topic. We're like bouncing around here between different narcotics, alcohol, whatever. Can we just stay on one thing? Like, is it alcohol we're talking about, or is it narcotics?
She was talking about prescription drugs.
Talking about prescription drugs.
Prescription drugs.
We're back on prescription drugs.
That's what my question is about right now.
So they would, most likely most employers will, let's say, move them. If the employee refused, you could order the test to prove that they were currently impaired or not. If they
But
were,
how do you test if they're impaired as opposed to if the opioids are in their system? With a legal prescription.
I don't know the answer to that question. I will say that in certain industries, let's say like a manufacturing plant, the HR person will be certified for that specific thing. That's kind of common among larger.
And I think that that's the crux of this question, though, that because opioid manufacturers have historically had way more political power than others, we've managed to get ourselves to a place where if you have a prescription and you're impaired, there's ways that industry is able to make sure people can continue on their whatever that prescription is and still maintain their job. And somehow it's not possible. HR people aren't able to be certified to do the same thing as it relates to cannabis. And so like everything you're saying seems to me to be consistent with what everyone else is saying in the proponents of this, which is it is possible. And it is possible to distinguish. And just because you don't have a marker for current impairment tied to marijuana doesn't mean that you can't identify impairment and make other decisions about safety or whatever it is on the job.
Yeah.
Would you agree with that?
I would agree. I think the only qualifier I would say would be with prescriptions, right? If it is an diagnosed, let's say, disability or a health condition, the employer would be making certain accommodations for them. So the employer would be held potentially accountable for discrimination under or like ADA discrimination versus not potentially if they weren't diagnosed.
But that's not
so it's a fuzzy area. I would say.
I feel like it's kind of jumping around because on the one hand, you could say the same thing about medical marijuana, and yet it seems, as I understand it, it is possible for somebody to be let go or disciplined for medical marijuana, because that same thing that you just described about the having the diagnosis applies for opioid, doesn't apply to medical marijuana. That's what we just established a minute ago. So that same logic apparently doesn't apply for medical marijuana. It only applies for opioids. Again, that's, I think, this distinction that we're trying to make is there's systems in place, there's processes in place. Somehow those processes work for opioids or other chemicals that might be in someone's drugs, but can't be used in this case. And that just kind of drives home the point, I think, that some of us are looking for from you, which is rather than saying no to this, no, we don't have biomarker tests. There's elements in this bill, and the sponsor said herself that she's open to engaging with and recognizing this may not be the perfect framework, but everything you're saying suggests that there is a framework and it is possible to identify and to distinguish. And so my request is that you would work with the sponsor, work with the tools that are available for cognitive impairment testing. I mean, in theory, you could have somebody walk in every day and instead of peeing in a cup, they could pick up an iPad, right? Like it would take less time. It would probably be cheaper.
Well, to be sure, I mean, this bill is not, I mean, we're talking a lot about medical, whether it's medical prescription drugs or medical marijuana. This bill is all of the above and recreational.
Okay, so two things that are happening with that. So one is medical marijuana still gets caught up in the same problem that this bill is addressing. But from a technical perspective, if you can identify impairment, whether it's medical or not, I mean, then it becomes a moral judgment. Someone has a prescription or they don't, right? But if you can identify impairment, then you can identify impairment. And so if you can identify impairment and make safety decisions, then you can do that with any legal substance or any prescribed substance. So I'll leave it at that. My request is that you work with a sponsor because it sounds like there absolutely is a path that could work. And I thank you in advance for your time with that.
Yeah, I think, you know, you had first asked is like, do you understand that there are, or do you agree that there are tests out there? I agree that there are tests out there. Now the efficacy, you know, I'll take the professor at his word. It's probably something I'll do some more research on. More importantly, kind of ping our members on it about, you know, are these tests out there available? What's the efficacy? What's the peer review on these tests? Those are very, very important things, I think, to keep in mind as we move forward before we just say, well, we know there's tests out there, but are they good tests?
Delegate Queen.
Started with Delegate Charkoudian. So I've been kind of confused about this whole this medical marijuana versus recreational. And I know like you said, we've been changing laws very quickly, but when we instituted medical marijuana, did the small businesses and the chambers provide some, you know, regulation and standards of what we do with individuals that are, you know, using this for a medical reason? Did we not address that? The medical piece.
I would just say in you know, Mike Chapman for the small businesses, most employers accommodate medical card holders. It's obviously position-based, industry-based. There's a lot that goes into it. You obviously still can't use if you're a heavy, you know, machine operator or something.
Like I can with opioids.
Yeah, and if that's the case, you have to use on the job. You're not going to be operating heavy machinery, right? I think that's where it's been addressed the most. And like I mentioned earlier, I recall a bill passing dealing with you know, you can't refuse to hire somebody, certainly if they hold a medical card. But I think that's
so the medical piece of it. Then we have ways.
It's kind of been moving, I guess.
We kind of have figured out how to deal with that, and we treat it similar to, I guess, because opioids is one of the ones we talk about that somebody might be given because they had an operation, they had pain or whatever. And they tell you that when you get the opioids, don't use heavy machinery and stuff like that. So, but you've accommodated that.
Many employers have.
Okay. So the issue then you have with the bill would just be recreational use. That's the problem. And we've been trying to align recreational use of marijuana, like recreational use of alcohol? Is that where you see us being? Because I don't consider use of opioids recreational.
Well, look, I mean, the goal of the bill, right, is essentially create a protected class of people, allow them to bring a suit for discrimination against their employer if they are disciplined for using cannabis recreationally. That's the goal of the bill, from what I understand. Our position on that is, number one, I mean, as I don't want to relitigate all the testimony, but what the system that's laid out for an employer in this bill is not only confusing, quite frankly, it's almost unworkable. At first glance, when I read the bill, I said, okay, this new language, the first big chunk of new language says, I can do this, but then the next set of language says I cannot do this. And so again, going back to my written testimony, this bill is laid out right now, in addition to the discrimination aspect, which leads to all sorts of legal ramifications to an employer. Just the construction is impossible.
I would agree. I think that the chairman said that using the term discriminating gets a little makes it into a whole separate issue. But right now, so we can get the medical piece, I guess, figured out and together. You think we could come to something we could agree on that part? Is that reasonable to say?
I don't want to. I would have to go back. No, to be perfectly honest, Delegate Queen, to be fair, I would have to go back and look at my files, because I know the medical issue has been before this committee before, even judiciary, I believe. I would have to go back and look at that and see honestly where the law is right now and stands on that. To be perfectly frank, my focus today has been on the recreational portion, as well as how that impacts an employer and their ability to frankly institute a drug policy at their workplace. So the simple answer is I'd have to get back to you.
Okay, I think at a minimum we should have the medical handled. I mean, that should be done, I would think. Right, and if it's not, we need to get that straight before we even talk about recreational.
I would say we certainly do need to get the medical worked out if it isn't already. Sure.
Okay, thanks.
And Andre.
Thank you, Mr. Chair. Just a level set for me, and I'm going to circle back to the chairman, what he asked earlier. Other than the sponsor's name on this particular piece of legislation, is there anything that you like about this legislation?
I like the sponsor just fine. I think the hiring piece is consistent with what we see in the medical side. I think the problem becomes on the impairment, the discrimination component, discrimination suit component. I think that there's a lot to work on, is what I'm going to say.
So I don't want to belabor this issue. I just wanted to know, is there anything that you like about, yes or no?
So if you look at section 2605A5, it allows an employer to prohibit the possession and use of intoxicating substances during work hours and to take adverse employment action against an employee for possessing, using. Now, an interesting point here is that House Bill 525 does not include this language. The Senate cross-file does. Possessing, using, or testing positive for these substances during work hours. This is consistent with many of the drug policies employers already use. So in that regard, sure, there's something we like about this bill.
Okay, and finally, based off of what you said and what you don't like, have you had any conversations with the sponsor?
I personally have not had conversation with the sponsor, no.
So you've had this piece of legislation before you like things in it, but you haven't had conversations. You like and don't like things in it, and you haven't had any conversations with it.
Delegate, I have spoken with the bill sponsor multiple times about the bill. We have made some suggestions on things we think could improve the bill. dealing with, exemptions for safety sensitive positions, which is common in bills like this that other states have passed, trying to bifurcate the type of testing to not cut off future technologies. I was a little disheartened to see that none of that was really discussed in the presentation of the bill, but we have been in contact, yes.
Okay. All right, thank you very much.
That concludes questions for this panel. Oh, sorry, young lady. Delegate Turner,
My little teeny.
go ahead. You got a little question, go ahead.
Okay, thank you. So all four of you gentlemen that's up here, since I don't know your names, y'all all against this bill, correct? What's your fear about this this bill? What are your fears about the people's rights? We have all the labor people that got up here and talked about, different discriminations. Do you have a fear that you just don't want this in writing? What do you have a fear about this bill? And just like my colleague over there, is there anything that you like about this bill or you don't like about this bill? What seems to be the problem with all four of y'all?
So respectfully, the fear with the bill, the fear with the bill is that if I'm an employer and I have an employee that shows up to the workplace that's under the influence, and if I take an adverse action against them, and I am not showing by preponderance of the evidence and all these other things that the bill lays out, that I'm now subject to a discrimination lawsuit. It's not discrimination as some of the more, well-known protected classes, but instead now it's a protected class of cannabis users. That's the fear. And when it boils down to is this is now under the same framework as discrimination lawsuits based on, gender, race, all those other things. Now we're including a cannabis user.
Y'all knew that cannabis was coming, okay? And you had to put in some new rules in how you're going to handle employees. But I just can't understand. We're trying to understand the people's rights that they have so they won't be discriminated against if they have this problem to do with cannabis, okay? Not the drugs. I ain't talking about the big drugs, okay? But I'm talking about cannabis that we just voted on this. It ain't even been a year or so or whatever about, and now y'all employees, you're the employer, y'all have a problem in taking care of any of the problems and protecting your employees if there is a problem on this bill? The employees has rights too. Wait a minute, we got rights too. And I mean, they all need a job, okay? Everybody makes a little mistake sometimes. Y'all have not talked about how y'all could get together and come up with something that y'all can agree of not just saying no, okay, that we can work together on, because y'all need the employees to get this job done. You got classes, maybe y'all can put them through, or you have a committee that you can talk to these employees. I mean, sometimes you can't go by the looks of them. Oh, I think he's high and he's on something, cannabis. There is a way that y'all can help the employees instead of hurting these employees. A lot of these employees, I mean, they got up here, these unions got up here, they need a job, okay? And we voted for this cannabis now, so now we need y'all to come back and help us, not hurt our employees, but help us, help them to take care of the problems that they're having. She put this job in because of people that we've been trying to help. Okay, so I'm with her. I kind of like the bill myself. Okay, but I might not, everybody else in this room. But I feel that it's something that needs to come out of this bill, that instead of saying no, work with the sponsor. Maybe y'all can come up with something, negotiate about how to handle some things, and then you can keep some good, happy people to work for you.
Isn't that so?
Isn't that so?
Thank y'all very much. I appreciate everybody. Again, gentlemen, we need to get this moving. We're gonna move on to our next panel. Sarah Price, Steve Sohaski, Pam Casemeyer.
Good afternoon, Mr. Chair and honorable committee members. I'm Sarah Price here on behalf of the Maryland Retailers Alliance. Our primary concern with the bill is the ability to continue testing. I understand that there are cognitive tests that can be performed to determine active impairment. We want to ensure that should there come a time that a biologic test is available to determine active impairment, that is still able to be used by employers. There is a slight language discrepancy between the House and Senate version of the bill, where the Senate version specifies that testing can continue explicitly and the House does not. We have shared this concern with the sponsor. We look forward to working that out should the bill move. Thank you.
Mr. Chairman, members of the committee, Pam Casemeyer here on behalf of the Maryland Delaware Solid Waste Association. I also wanted to note that Lewis Campion from the Maryland Motor Truck that was supposed to be on the last panel couldn't be in town today. So I do work with them too, and I'm speaking with them on their behalf, and also would like to call attention to written testimony that you got from the long-term care industry, adult daycare, home care association, and Lifespan, with some concerns about the bill too. But I have to be brief anyway, but we signed up opposed, but opposed unless amended. We could have signed up support with amendment, but we wanted to be sure there was an understanding about how significant our concerns were. Largely in our industry, maybe I'll use the example of the workers on the back of the garbage truck that are riding on the back of the garbage truck and could fall off. Many of the other jurisdictions that have dealt with this issue have had safety sensitive positions that could be addressed differently than across the board. And this is largely related to the fact that for some of those positions, you can't even determine whether they're in. So do you want us to wait until they run over their employee or fall off the truck? So we want to work with that language, but some of the other concerns really weren't opposed, but concerns about the clarity of the language. Like discriminate includes terms, conditions, or privileges. Does that mean I can't make them do something different that day and not ride on the truck? Maybe they work in a different position. That question isn't answered. The preponderance of the evidence language is a little concerning. So there's some technical manifest specific articulable symptoms. We really think it's not the intent. It's not to ensure that there isn't. It's really, it needs a lot of word working, which we're happy to do, but I think otherwise there'll be unintended consequences.
Mr. Chairman, committee, my name is Steve Sohaski with Creative Risk Management Solutions. I'm also a member of ABC Greater Baltimore, and I'm coming at this from a safety perspective, especially on job sites. As some have already alluded, there are infinitely more potential hazards on a job site where impairment or even the use of drugs can, specifically marijuana, could negatively impact. And safety sensitive positions is something that I think should be looked at and were missed in this bill, because to what you said earlier, there
are definitely things that may occur in one industry that may be more significant to have these taken care of. I'm sorry, removed.
Thank you. Sir, I have a question. For just any of your people you represent. So if they're at work and one of their employees is drunk, smell like alcohol, a little impaired, what would their recourse be?
Do you mean, would they be sent home or, I mean, it could vary widely.
Sure, they
Theoretically,
can fire
somebody
them,
could be
right?
sent
You just
home.
walk up, you know what? You're fired.
It may depend on the terms of employment there, but yes, at will employment theoretically, yes.
There you
somebody could
go,
be
right? Because
fired.
that will employment. So presumably they can also do the same thing if they smell cannabis and see somebody acting disoriented, correct?
Theoretically, yes.
So it really sounds like this bill centers around two things. They just don't want random urinalysis to do that, meaning you actually have to catch them because you don't, when you do urinalysis, you don't check for alcohol, right? Most people only check for cocaine because it's only in your system 3 days. Carl, right? I don't know. You knew about the weed. That's what I was asking. But my point being, so without creating a protected class of people, because it sounds like honestly the two problems with this are urinalysis and guess what? The hilarious one, unions. Because everybody else, oh no, because everybody else can be fired. And the unions haven't negotiated this properly. That's on them. Because at the end of the day, most of us, I could go tell any of my paralegals right now, you know what? You got to go. I ain't got to give a reason. So without creating a protected class, if we just did away, except for a unfortunate, hard to do laundry list of certain things like adult daycares where there's an adult with somebody every day, or these security, certain security, safety sensitive positions, construction. If we did away with random urinalysis, you would just fire them like you would a drunk. That's what it sounds like the solution is, that doing away with random urinalysis may not, for certain situations, may not hurt like your people and the retailers because they can just fire them, right? They don't need a urinalysis to fire somebody.
Right.
So the people, it seems like they're left in the dark, the people whose unions didn't look out for them, did not negotiate this and need to negotiate this the next time it comes up. Medical marijuana has been around a long time. Very disappointed in that. But it sounds like the issue that everybody's trying to get to is, are urinalysis for marijuana in most jobs a good litmus test? And are they fair? And we don't have to create a protective class of people to deal with that. So I appreciate your testimony, but I'm still trying to, I understand that, we don't have a tighter way of doing it, but we do have a way of dealing with individuals that are intoxicated on the site. Not for you, I get it. And I understand the dangers for certain individuals, but retail, come on now.
We do have warehousing.
Okay, well, then, and those are things we can discuss, even though I would ask the question, but then how do you know if they're drunk or not?
I could buy a breathalyzer.
But who does? Please. If you're telling me your employees buy breathalyzers, your people do?
I'm saying it's an option.
Yes.
Whereas right now
no, mostly unless they're unionized, I'm assuming they walk up, hey man, you can't drive that. You're drunk. Go home. They don't have to get a breathalyzer. They don't send them to the hospital to draw blood. They send them home.
Right. I'm just saying you could.
Oh no, you could. I got you.
The question is, how do you test?
Sure, but my point is, how is it approached? And I'm just trying to simplify this without creating a Civil Rights Act of 2024 for cannabis smokers.
Concern. Yes.
Yes. So thank you guys very much. I believe that's everybody on this panel. We good? Any questions? Okay, guys, thank you very much. We're moving on to, hey, we only have 4 more bills to go. Do we have anybody here from Cecil County? House Bill 843.
Thank you, Mr. Chair, and genuinely appreciate your efforts to be solutions-based in this committee. I do commend you for that. Delegate Hornberger here, HB 843. This is a local delegation bill that's already been voted on and approved. And this is at the behest of our county council and county executive. Our original intent with this bill was to be able to empower our liquor board commissioners to be able to go out and do inspections in the community. We were really trying to target gas stations and some of the bad actors that are selling products that are not legal in essence. However, in working with bill drafting, the only solution that they could offer us was the ability for those inspectors to go and look at licensed facilities, licensed cannabis producers, processors, and retail establishments. So that was the posture that the bill was written in. Basically, this would allow our liquor commissioners to go into these business, announce their presence, and do inspections. Beyond that, they won't be issued firearms. They won't have the ability to shut down the business. They won't have the ability to issue fines. They could simply do information gathering, and this would most likely be at the request of a citizen or a customer. Compile that information and then send it to the authority having jurisdiction in the state, which is the MCA. So pretty straightforward bill. We do believe that this is needed because from what we can gather, and I have had some conversations here with the law enforcement arm of cannabis, and we all know that this is new. We just feel that this is another set of eyes and won't hurt anything to have them looking over this industry. So with that, we ask for a favorable. Thank you.
Shut up. I get your point. I hope you do understand and you said you put this in for your county exec?
Yes.
Okay. Thank you very much, sir.
Thank you.
See no questions. We have one unfavorable that I know will be brief, if at all. Oh, somebody's ready to fight.
Good afternoon, Mr. Chairman and members of the committee. I'm Ashley Bagwell here this afternoon on behalf of the Maryland Dispensary Association, respectfully in opposition to House Bill 843. We don't think this bill is necessary.
Thank you for your testimony. I conclude this hearing. And again, thank you.
Y'all last weekend.
Appreciate you, everyone. Yeah, Delegate Miller.
Yeah.
I know you've been sitting very patiently.
It's been enjoyable and educational and informative. So
Yeah, my vice chair can be something sometimes. You gotta watch it.
Oh, there. Is it okay if I bring my panel? Okay, thank you. Yeah. All right. Good afternoon, Mr. Chair, Mr. Vice Chair. For the record, I am Delegate April Miller, and I'm here to present House Bill 1243. First, I would like to say that I appreciate the work that was done by this committee, most especially the chair, in protecting children from the risk of accidental ingestion of cannabis and cannabis products. I am first to admit I am not a subject matter expert on this topic, but what I am is a mom. And when I hear of children grabbing a bag of what they think is candy or chips and ending up in the ER or the ICU, that caught my attention. The accidental consumption of marijuana edibles among children 6 and under has soared. The journal Pediatrics reported that between 2017 and 2021, cases of accidental ingestion rose 1,375%. I bring this bill forward in an attempt to close a loophole of the sale of empty packaging of cannabis, or that cannabis and cannabis products could then be placed in, and would violate the well thought out provisions of this law. It is currently not illegal to manufacture or sell the empty packages that are ready to fill and may look something like this. And I apologize, I was going to have them closer on your desk, but they may look very familiar to you. And they are what this bill was trying to prevent. But if you pull out your phone and you just search THC Mylar bags, just pull it out or on your desktop and see what comes up. That's how I found the pictures of these products. And when I was in committee and doing some research and I pulled this up, the person who sits next to me, oh, Mike and Ike's. I'm like, no, you better look a little closer. So think about how easy it would be for a child to pull this up. It literally says Mike and Ike's, except down here it says 600 milligrams of THC. Yep. And then Nerds Ropes. We've got, oh, Butterfinger Cannabites. We've got Funyuns. Who didn't love Funyuns? And of course, everyone's favorite, Doritos, I know, see, I gotta, anyway, I could leave them for you guys, but that is also THC, 600 milligrams. I also have my cards for if anyone would like them for glasses. All right, and then brownies, Wonka brownies. So again, selling these, it's not illegal to sell the packaging. And so when someone who has manufactured cannabis products and they're dispensing them or has a license to dispense them, they can buy these and they can fill them and they can sell them. And it goes against the spirit of law. So my attempt with this law is to close a loophole. I will leave that to you. There is also, we lost our virtual panelist.
Might be there.
Okay, we'll see. We have a virtual from General Mills that's wanting testimony, but thank you for your consideration. I appreciate it.
And Sarah, I actually called you up. It says, I think it was a mistake. It says that you were favorable to a bill in this committee.
I know, it's shocking.
Okay,
I know.
Sorry, go ahead.
Just trying to catch you by surprise. Sarah Price here on behalf of the Maryland Retailers Alliance in strong support of this legislation. We had the language from this bill in the Senate version of the cannabis legislation last year. It did get through the Senate. I understand that I understand that using this packaging is illegal. I know that legal sellers cannot use this packaging. We are concerned about the people who are selling illegally who may use it anyway, or people who are ordering in from out of state. We want to try to stop those bags before they get to the illegal point so that anyone who is purchasing these items illegally, like if I were to have a guy who's selling Stonio's, Oreos, and I purchase them and then maybe a niece or nephew finds them in my house and thinks that they're real Oreos. Yes, I purchased those illegally. We're using that as an example. I'm not actually doing that. We understand, but we just want to make sure that we are eliminating the access to this packaging before it gets to the point of being in somebody's house. And we know that there has been a market increase in children who have had to seek medical attention due to consuming edibles that use packaging that looks like products that they're familiar with. So we're trying to reduce the chances of that happening. We think that this would strengthen the current restrictions on packaging, and we hope that you would vote favorably. Thank you.
And I guess I was just asking you, I wrote down like who buys these things because it's already illegal to sell. And you saying the people that sell illegal cannabis. I'm like, this will be the least of the worries then. I mean, I was like, them getting caught up, possessing illegal packaging is if they don't follow the big laws, I don't think they will worry about the little ones. And I guess that's what I was just trying to say. Is this something, does Amazon sell this? Because I'm trying to figure out what it is I'm trying to do here.
Amazon generally has followed the law on this one. If you search for edibles bags, it's pretty tough to find them. I could find them last year ahead of the hearing on the legislation here, and then it seems like they've sort of cleaned up their act in the meantime. There's a website based in China called DHgate that it is extremely easy to find these products on. I understand that we can't tell China what to do.
Right, because I'm saying that's what I want to get to is
right.
I really want to get to the enforcement mechanism of saying this and trying not, I don't want to get into some intellectual onanism by putting bills out that don't actually have any kind of impact. And I just don't see where the impact is because we've already got people that are going to get them for selling the illegals. I don't know who's going to enforce this when it comes to China, unless we're just trying to make a statement. Help me out here.
So I believe it would restrict not only the sale, but also the purchase of the bags. So if you can find.
Yeah, but who does my AG go after?
If we can prove that a sale was made to an individual in Maryland, then we've got both ends.
That sounds like a big hunt. I mean, I got you. I just was trying to figure out what I was missing here because I know they're not going to sue Temu successfully. And I was just trying to figure, they would have to find somebody who purchased it, or I guess if they found the packaging somewhere, then that would be its own crime. But this isn't a criminal sanction, is it? I don't believe it's a criminal sanction.
To sell the empty packaging? I mean, to sell the empty packaging? No.
But not to possess it. I mean, do you want it to be a criminal sanction? And to possess it also be a criminal sanction? You understand? I'm trying to.
I know where you're getting at with it. I think what we're trying to, well, I know what we're trying to do. One is we're trying to protect kids. That's the first thing. And you got that. And you tried, like I said, through the legislation. And we just see that as a loophole that the empty packaging would be available even for licensed dispensaries here to repackage and resell them. That's also a possible concern that could happen or pop up. I don't know. Again, you're the subject matter expert. You don't think that can happen? Okay.
I mean, I would really be furious at Will Tilburg if some dispensary was
Okay, but all you.
I got you. I appreciate the intent. I don't want to cross-examine too much. I know it's getting late.
You can, it's okay.
But
that's
thank you
fine.
guys very much. I appreciate that.
Thank you.
We can move. Is there a virtual witness? That's what she said. But you, go ahead.
So Delegate Miller, real quick, would a current seller is a current seller prohibited from selling this separate? Like, could they sell this in addition to selling cannabis separately, as long as they're not together? So could they, you get what I'm getting at?
Yes, yes.
Okay, so that could be.
Yes.
So, Mr. Chairman, that could be a fix, is that a licensed seller in Maryland would be prohibited from selling this packaging separate. I mean, obviously they can't sell it with the stuff in it, but they would also be prohibited from selling. I don't know. Anyways, thank you.
Yeah, because it really just says the holder of a cannabis license issued under this title may not purchase an empty packaging that, if used to package cannabis, would violate a provision of this title.
So packaging or sell. Yeah.
Why would they? They're gonna sell to the competition. They're gonna sell to somebody who's gonna make drugs illegally? All right.
We're trying.
All right, I got it. No, I appreciate it. I get the intent. I was just trying to figure out the policy. Thank you guys very much. Thank you. Go ahead, Weibel.
Thank you. It'll be short. I'm trying to understand this bill as well. So right now, is the packaging regulated by the Cannabis Commission?
The packaging for legal products. So if you were to purchase legal products right now, there are restrictions on what can be on that packaging.
Okay.
Yes.
So that makes sense then. So what these are packages that aren't legal under the current law.
Correct.
As regulated by the Cannabis
But it's
Commission.
legal to sell them because they're empty.
And then, okay, right, get it. All right, thank you.
And my understanding is the virtual witness is currently in the waiting room. So his name is Mike.
Okay, Joe, sorry, when you log on, you can go ahead and start speaking.
Oh, there we go.
Go ahead, sir.
All right, thank you. My name is Mike Geisey, and I'm the Chief Intellectual Property Counsel for General Mills. General Mills is a Fortune 500 company based in Minneapolis. We make food the world loves. Beloved household names including Cheerios, Betty Crocker, Annie's, and pertinent to today's discussion, Cinnamon Toast Crunch, Trix, and other cereals that are well known to families and children. I'm here today because, as you've heard, sellers of marijuana edibles purchase pre-printed bags with our company's brand imagery on them. They fill the bags with marijuana-laced consumables, including adulterated versions of our cereal products, and then they sell the products to consumers. In addition to the statistics quoted by Delegate Miller, I'll add that between January of 2021 and February of 2022, poison control centers across the U.S. fielded over 2,000 calls regarding THC exposure, and of those reports, 41% involved pediatric patients. General Mills and our peer food manufacturing companies spend millions of dollars every year to ensure that our food meets stringent safety standards. When the public sees our packaging and sees our names on packaging, they rightly expect that the food is safe for everyone to consume. Unfortunately, these marijuana edible makers are not held to those same standards. As Delegate Miller also mentioned, it's not illegal to manufacture or sell empty bags pre-printed and ready to fill. This loophole means that law enforcement can only act after these unsafe products are on the market and potentially in the hands and mouths of children. The legislation presented today helps to close that loophole by prohibiting the purchase of the bags by those who hold a marijuana license in the state of Maryland. As more states set up marijuana markets, now is the time to take this extra step to protect your constituents and especially children from the ingestion risks posed by these copycat edibles.
Thank you very much, sir. Seeing no questions for this panel. Thank you very much. I guess this concludes this bill hearing. We're now on to House Bill 253. We have Wilbur Tilburg, Warren Carr, and Debbie. Those are two witnesses. He goes by Will Tilburg. Sorry. Thank you very much, sir. Go ahead, Will.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. Having fun today in economic matters. Thanks for having us. HB 253 is a departmental for the Cannabis Administration that seeks to make technical changes and corrections to the Cannabis Reform Act. It was a very lengthy, comprehensive piece of legislation, over 100 pages, as finally enrolled. And as you may recall, there was some movement of the regulatory body towards the end. Originally, Alcohol, Tobacco, and Cannabis Commission was going to be primary. And then ultimately the new Maryland Cannabis Administration was created. So the real focus of the bill is some cleanup there of identifying the commission where appropriate and the administration where appropriate, as well as the Office of Social Equity and other clarifications. I'm happy to answer any questions on the bill. Otherwise, would urge a favorable report. Thank you.
Thank you, Chair and delegates. My name is Rusty Carr. I'm a resident of Mount Airy. I'm here representing myself and want to speak about home grow for just a minute. We did allow some Maryland residents to grow 2 plants or 4 plants if they have a medical card. However, we did not change the possession allowance. The possession allowance in Maryland is 1.5 ounces for regular or 120 grams for medical cannabis patients. One cannabis plant can yield way more than 120 grams. So technically, home growers who keep their harvest over 120 grams are breaking the possession law in Maryland, and I'm asking you to fix that and do that. Other states have up to a 5-pound limit for home possession. Previous versions of the cannabis legalization bill in Maryland, like HB 32, that had home grow, had possessions to allow what I call keep what you grow, so that whatever you grew, you could keep on premises, even if it exceeded the personal limit. So I'm asking you to, as long as you're doing cleanup and doing that, to clean up issues like that. Thank you very much.
Thank you, Mr. Tilburg and your panel. I do want to commend you and all your efforts for getting this thing stood up. You've done a great job, and we really owe you a debt. So thank you.
Thank you, Mr. Vice Chair. Next, we will go to House Bill 805 by the chair.
Colleagues, good afternoon. I know it's late in the hour. I'm always nervous going in front of this committee. I've heard reputations, so be gentle. Good afternoon, Vice Chair and esteemed members of my committee. Delegate Wilson, I'm here to sponsor House Bill 805. I want to speak briefly about this because I believe there has been nothing more than a tornado of misinformation about this bill. So our job here in 805, the goals were to refine the zoning restrictions for licensed cannabis dispensaries, ensuring equitable treatment compared with other and comparable to other entities while maintaining public safety. what we did, the first part we did is we made a clarification of unduly burden. And now explicitly includes zoning restrictions more stringent than those in 36-410, meaning you can't be tougher on cannabis than you were on alcohol. The political subdivisions may establish reasonable zoning requirements for cannabis businesses. They get to decide revenue allocation without imposing disproportionately burdensome fees, and they cannot impede license conversion compliance or demand contributions from licensee. You must ensure adequate supply for patients when it comes to medical marijuana, and at least 25% of the cannabis products must come from a social equity license. The distance are now 500 feet, no closer than 500 feet from schools, childcare centers, playgrounds, recreational centers, libraries, public parks, and places of worship. No closer than 1,000 feet from one another as far as the dispensaries. So what we're trying to deal with here is, and I want to start, the reason, the opposition that we have to this bill is the same reason I put this bill in. So I need the people that are, hopefully some people are listening in opposition to understand that their inherent distrust of governmental entities when it comes to placing things that may be considered vice is very reasonable. It is very disheartening to go through certain communities that with people that look like me and see that's where all the liquor stores are. It's even more disheartening to see people come in who don't look like me because that's where they want to buy their liquor. And that's what I was trying to prevent with this bill, because I wanted to make sure that people understood that we're going to do this the correct way, and I'm not going to let the counties do what they did with liquor with cannabis. So basically, this is going to provide some additional clarity and consistency to the zoning regulations. This is a comprehensive statewide regulatory framework for cannabis legalization, with the overarching goals of reducing the illicit market, ensuring broad and safe access, and that it is safeguarding public health. So to start with, I want to make sure that we understand that the number of cannabis licenses, we did a great deal of work. They're limited by statute to get that specific number. And the number of cannabis licenses overall for dispensaries is going to be 300 statewide. And that was after a great deal of research to deal with the demand. Now, we also made sure in the law already that the Maryland Cannabis Administration will award licenses in a manner that encourages balanced geographic distribution based on population and market demand. So it's not that somebody's going to be able to get a license and pick where they want to go. Or if Prince George's County is allotted 20 licenses, that everybody gets to say where they go and they just open up. We've watched that happen with smoke shops. We've watched that happen with liquor stores where they just open up. But see, that's not the process. And I honestly, I'm sorry, I just don't trust the counties to do it because I've watched what they've done. They complain about the way the smoke shops open up, but they give them UNOs and they give them health occupancy, they health licenses to open up. So we have another layer involved here. I've said it before, but I'll say again, we have the Maryland Cannabis Administration. They're going to be the ones who actually issue the license. Not before they get the location, but afterwards. And they do that in a way to make sure that, that we geographically distance it towards safe, where they're not spread out, where they're not clustered together. Let me stick back to my words here. Basically, the goal with this bill was to make sure that local zoning regulations do not unduly burden cannabis businesses or impede their ability to operate within the parameters set by state law, provide additional clarity for zoning requirements, protect sensitive areas. This legislation supports objectives of our state's cannabis regulatory framework. Now, there are amendments we're going to be adding on. Instead of doing the 1,000 feet, we're going to expand it to 1,500 feet, which is roughly a quarter of a mile between dispensaries. We're going to require Maryland Cannabis Administration to consider geographic distribution when issuing licenses. We're going to allow the filing of protests based on negative community impact. And we're going to maintain the existing zoning-based environmental protections, such as critical areas. This is a critical component to Maryland's effort to establish a fair and transparent cannabis industry. Now, again, we talked about the opposition when it comes to concentration of cannabis dispensaries, and they compared them to liquor stores. But I need you to really understand, let's start off with a few things. There are over 6,500 off premise alcohol retailers in the state of Maryland. There will be 300 cannabis dispensaries in the state of Maryland. Basically, Baltimore County has nearly 800 alcohol retailers. It will only get 18 cannabis licenses. Prince George's has 600 alcohol beverage license retailers, which I find shockingly low. And I think they're going to get what, 20 licenses for the entire county of 1 million people. So we need to understand that we're trying to create an equitable zoning regulations for cannabis while maintaining appropriate controls and safeguards for this entire business. And I say this because, and that's what I read, but let me finish explaining this. The goal was to make sure that we gave back to the communities that were disproportionately impacted by the war on drugs. And those license holders will be individuals from those areas. They will be mortgaging their homes, their houses, their futures to try and make these businesses work. The goal is not to cluster them in one area so they will feed off each other. That makes zero business sense. It makes zero sense to somehow cram them all into one area. As I've stated multiple times, I was never a huge fan of this, but since y'all voted for it, my goal was not to get Marylanders high, but to help eradicate the illegal drug market. That cannot be done if we shove all the license holders into an industrial area where we force individuals that don't live in those communities to drive to them. My goal is to make sure that all of those communities have their own cannabis dispensaries. You should not have to drive far to get to one. And I understand the mistrust of the citizens who may testify later. That's why I put the bill in. I did not have the faith of the individuals that have been giving out these alcohol licenses and clutching their pearls saying, oh my gosh, he wants a license. He gets to do it. No, you don't get to do what you want. We have extraordinarily tough standards. And we have this gentleman right here, Will Tilburg, that's enforcing them to make sure that it is spread out throughout this state, not just in each district and political district, but throughout the state in general. Again, I don't want people that don't live in your community driving to your community for cannabis, because that's what happened with liquor. That's what happened. We're not going to let that happen. I don't want people to, they're not going to be able to pop up like smoke shops, because unlike the counties, we're just not giving out licenses. And I know we had arguments when we were pushing this bill last year about, oh, everybody should get a license. And it's hilarious. Those are the same people complaining now because they don't want too many in their community. Yeah, see, that's how that works. This was thought out. This was not done randomly, and this is not about state control, but it is about protecting people, protecting communities, and protecting a now legitimate business. So I want to make sure we understand that we are not here to stuff them, to cluster them. We're not going to do, I mean, what's the old joke in the hood? There's a liquor store and a church on every street corner. We're not doing that. And yes, I would like you, every one of you, to have a cannabis dispensary in your neighborhood, so you ain't got to drive to mine. And with that, Will.
Mr. Vice Chair, members of the committee, Will Tilburg, Maryland Cannabis Administration. I actually don't know how to follow that. I'm here primarily today for questions. I know that there likely are some related to this bill. Just briefly though, why we're here. In the interim, since the Reform Act was passed, my office, MCA, has been inundated with questions from county and municipal officials about what reasonable means, unduly burden, and whether the foot distance limits within the Cannabis Reform Act were a ceiling or a floor. And so this bill really does seek to clarify those positions. These are questions that we have been getting, and the bill does a good job of balancing the interests of local jurisdictions with zoning, as well as the new social equity businesses that are coming online to provide them with business certainty as to what the ground rules are for where they can be cited. So with that, I'll leave it there and be happy to answer any questions.
And if I may briefly just expound on this one more time, because I see a lot of the people's buttons are lightning from a specific county, so I want to address. Yeah, that you're part of the reason we did this, because Prince George's County wanted to go ahead and stuff them all in industrial areas, which number one, they'll be very close to each other. They'd be feeding, these minority owned businesses will be just feeding off each other, and people that don't live in those neighborhoods will have to drive a great distance to get them. But I also want you to understand, so goes Prince George, and so goes everyone else. And where do you think some of these other counties, I'm not going to besmirch anybody who represents the county, but coincidentally, where do you think they would stuff all theirs? If you're worried about that happening, then you need to be supporting this bill, because this bill stops that. It confounds the imagination to think that we've worked so hard, set aside $80 million, set aside loans so minority businesses can prosper, and then just shove them all in the hood so they can be worried about getting robbed, so they can be worried about feeding off each other. It makes zero sense to have put that much effort into it just so they can rot away because they're competing against one another. There will be winners and losers. There will be people that will, and I mean that as certain people may get a license in a very dense area. Other people, that means other people have to not be in a dense area. You're going to have big ones, you're going to have small ones. But we've done this by population density. And what I was utterly unwilling to do is let these same county officials who put those liquor stores in your neighborhoods and those smoke shops in your neighborhoods be in controlling where these dispensaries go. They have a say, but the last word comes to the Maryland Cannabis Administration for the betterment of our state.
Not sure how to follow that one up either, Mr. Chair. Thank you, Mr. Chair. Well, thank you, Mr. Vice Chair. Mr. Chair, thank you for this bill. I'm glad you said at the onset that there's been a tornado of misinformation, because there truly has, especially in Prince George's County. But I just want to set a couple of things straight for the record. One, what happens if a county decides to put this in an industrial zone? Can we expect, especially in those areas, to be an increase in crime if we were to do something?
And I want you to understand, this is going to be $1 million industry. So let's say there's one in there. This is not drawing crime, okay? If you don't know, go visit one. It's not a smoke shop. And believe me, I'd like you to visit one that's licensed, not one that has, just because they have a weed leaf on the front window, that doesn't mean they're a dispensary. These are very elegant, and I mean, I was very impressed. I went by one after church just to see how it looked, because I've never been to one. It was amazing. And I say that, so they're not going to be what draws crime. Now, you have a situation where you're dealing with an industry that may deal with more cash than normal. So we have to make sure they're in a safe place. So it's not that it draws crime, but at the end of the day, what you're doing is wherever those businesses are, the vacuums that are created are going to be filled by the illegal drug market.
And part of your goal, correct me if I'm wrong, Mr. Chair, was to get rid of the illicit drug
That's
market.
correct.
Correct. I'm going to read something that one of my constituents actually wrote in that I'm reading here in our committee testimony. This bill would essentially allow every smoke, vape shop, and gas station to be able to sell marijuana. Is that true or not true?
And see, that's what I'm saying. And it becomes irresponsible at some point for some of the county officials to propagate these lies. There's only 300 licenses. I made very sure, again, I fought against a lot of folks about how many licenses we should have. No. We want a safe market, a regulated market. The dispensaries will be the only ones allowed. We're not having vape, the CBD derivatives, all that stuff. We've gotten rid of all that. You can't sell any of that. We've got enforcement mechanisms to make sure they can't do it now. They're not going to be able to do it then. And nothing about this bill that I'm putting out has anything to do with smoke shops. I hope your county steps up, squares its shoulders, and does what they're supposed to do to get rid of these smoke shops. We don't regulate them. They do. And look what happened.
Thank you, Mr. Chair. Will, this is a question for you, because I think there's a perception with some folks in Prince George's County that this is not a thriving, booming industry. And with the creation of the social equity licenses, this is going to be a tremendous economic benefit for folks in my county in particular. How much have we seen this industry generate since its existence in its legal form?
Yeah, thank you, Delegate. So since July 1st, a 6-month period, so from July through the end of the year, there were more than $550 million in retail sales statewide. Of that, $350 million were in adult use sales. We anticipate it to be over $1 billion marketplace in the first full year. And then it creates thousands of direct jobs through employment, and then tens of thousands of jobs in construction, IT, security services, all of the ancillary related businesses. So it's tough to quantify, but it has a really significant economic impact.
Yep. And what we're talking about here, and I'll end on this point, Mr. Vice Chair, is $1 billion industry that can generate jobs, especially for folks who have been impacted by the war on drugs. And because of county zoning laws, we can all of a sudden see an illicit market come back and hurt the same people who are trying to quote unquote protect folks. Mr. Chairman, and to you, Will, and to the Maryland Cannabis Administration, let me just say as a representative from Prince George's County, that I think this bill is significantly important. If you walk through or drive through Prince George's County, you'll see an onslaught of liquor stores and unhealthy eating and a whole lot of things that impact our folks in our county. And what we're trying to do here is ensure that this bill in particular sets up a framework that allows every part of the state to be equitable when it comes to cannabis. So thank you for answering those questions, Mr. Chair. And again, thank you, Will, and to the Maryland Cannabis Administration.
Well, at the risk of getting on your bad side, as a representative from Prince George's County and a former county council member, I do know the struggles of trying to deal with some of those, but I'm gonna go just a little different right now. So I will say that I don't know all of the history of how all of the liquor stores got concentrated in 3 districts, basically. And so I can't speak to that, but what I do know is that we have tried for years to rectify that. And it wasn't until last year that we were able to actually be able to transfer licenses outside of the district. And then there were some senators who said, well, don't bring them into my district.
Yep.
So we still have a problem with concentration. With you know, the vape shops, with smoke shops, we've had that discussion. We'll continue to have that discussion. I want to continue to pursue that. And we may have to do a couple of things just because of the definitions, and that's why they're able to get use and occupancy permits. So that's a different issue there as well that needs to be fixed. And it's going to take both state and county to do that. And so I'm putting that out there, and I'm eliciting your help right now. But the other thing that I want to say is that I appreciate you increasing the distance to 1,500 feet. I'm going to respectfully ask for another amendment to include liquor stores in that. As far as the distance, we have pre-existing daycares. I could pull up the language, but you know what it is. Some of the pre-existing things. Why not have pre-existing liquor stores? And the reason that I ask that is because of the concentration. I can think of 2 locations in particular, one in my district, one in another district. The one in the other district, there are 2 stores that are actually cat-a-corner from each other. That's not
2 what stores?
2 liquor stores, I'm sorry. And that I can't measure distance. I'm not really good at that, I'll admit. But I don't think that that's 1,500 feet. I don't think that's a quarter of a mile. And I can share with you where that is. But then if you go right down, you know, Route 202, which straddles a couple of districts, you have 3 stores that are within a quarter mile. And my concern is that if one of these dispensaries wants to, or 2 dispensaries want to go in, and they are prohibited, if the county is prohibited from allowing them, if the county is prohibited in the distance, then we could still have a concentration of liquor stores and dispensaries within a quarter mile or a mile.
And therein lies the rub, though. You have 600 liquor stores in your county. Where would we put in the dispensaries? I can't punish for the sins of the people that put them there, the people coming in, because the whole goal was to create access for everybody. And just like you said, we could probably find miles of areas where we could not, I'm talking about inside the Beltway, where we could have no cannabis. So that's where the illegal market would grow. I understand your point, but and again.
And you did use my word. You must have been in my head, because I think that we're being punished for the sins of the father.
Without a doubt, but the cannabis these are $1 million locations. They don't want to go in bad neighborhoods either. So they don't want to be in a neighborhood. It's like
They want to be where the money is going to be.
but
And the money is going to be in the where it's
and
concentrated.
so without a doubt, but at the same time, the state goal is to make sure that they're spread throughout the political what's the language you guys use? The political subdivisions, the counties, and the state. So again, we can't. We're not going to put two cannabis stores right next to each other. Your issue about not putting near a liquor store, then I don't think we'll find a place inside the Beltway that we have a cannabis store, and that's a problem.
I think that we can work that. I think that it would be okay. I think that though we need to give the jurisdiction an opportunity because the language in the bill says that you can decrease, but you can't increase. 1,500 feet. Is it 1,500 feet?
That's what we're moving to.
1,500
That's
feet.
a quarter mile.
But that's not very much distance.
But see, here's the thing. I want to make sure it's understood. We don't want, because we didn't want, you heard on the floor last year, somebody saying they got to be a mile apart. We a mile from a daycare center. So we came in with those baselines. It is the state that is going to decide where they should go and what locations. Just because they want to go there, that doesn't mean that's where they're going to get to go. This is not merely, and I know it's hard to fathom, this isn't a vape shop that, well, you got to give them a license because they opened up. They won't get a license until they find a location. Was it pre-approved? It's a pre-approved license. It doesn't go, they don't get to operate until they've completed all the inspections, all the backgrounds, and they pick a location as we see fit. So all I'm saying is just because it's 1,500 feet, that doesn't mean our goal is to set them 1,500 feet apart. I just don't want counties coming in saying, well, we said 2 miles. Well, we said a mile. We know what, we're going to start building churches, or we're going to build playgrounds, so we can't have any, because that's what's going to happen. Well, then we just don't, and that's how they'll move them entirely out of their county. We'll end up with dry counties, i.e. a vacuum where people are going to sell illegally because they'll just have liquor stores and enough there to where we have no dispensaries in the county.
I understand what you're saying. I'm going to continue to argue for the people in my county who are inundated with liquor stores until we can move them out.
Can I ask you another way?
Yes.
So you're saying those same citizens don't want dispensaries anywhere near them?
Well, of course, nobody wants it near them.
But
that's
so
always
they're not
the
going to
case.
use them. So they're not going to use them. You see, that's where we're running this really not in my backyard thing. Right. And I got it. But again, if my goal and our goal is to get rid of the illicit drug market, it makes no sense that people are being murdered for cannabis. Then we can't have huge areas, especially inside the Beltway.
So my question then is for Mr. Tilbert, right? So then your organization, your department, then when someone applies, you're going to go out and when somebody applies, you're going to have an idea of where they want to go. So you're going to go out then and say, no, you're too close here. No, you're too close there. These are too close together. Is that what's going to happen? Can we assure our residents that that's what's going to happen?
So what is in the law now is MCA, our agency, has to consider geographic diversity across the state and then within jurisdictions. And what Delegate Wilson is proposing in his amendment is we expressly lay out within our regulations how we will evaluate concentration within intra-jurisdiction prior to award of final licenses. So right now with dispensaries, there's 9 additional ones that are coming to your jurisdiction maximum in Prince George's. And what the amendment does is those 9 awardees, before getting a final license, they have to have that location approved by MCA. And we have to consider the distribution within the county so that they're not clustered together beyond just the 1,500 feet, so that there's equitable distribution within the jurisdiction. So yes is the answer, that this is an evaluation the state will be doing in the distribution of the licenses.
I won't belabor the point, and I think that we'll just have more conversations. So thank you, Mr. Vice Chair.
Thank you, Vice Chair. So I only have two questions, and I
I think I'm hearing the Prince George's County conversation and mine on the Eastern Shore is going to be somewhat different, but let me just start with the example and then I'll ask a second question. So what we found in Wacomico County and just, there is a medical marijuana dispensary, if I've got the phrasing correctly. It's in the middle of Salisbury. And when we legalize marijuana, are they now selling legal marijuana products? Is that what's happening or is that not the case?
Yes, all of the medical businesses were able to convert to medical and adult use.
So my brother and I were traveling to a retailer that was about, I don't know, a half mile down the road from where this was. And it was like, it wasn't New Year's Eve, but it was like a few days before. And the street was mobbed with cars. And I was curious about this. I was like, what's going on? And we went to the retailer and they're like, yeah, man, ever since this thing became legal, this business is like totally upsetting everybody because it's like a strip mall sort of within a area, and because they don't have enough parking, like they don't have enough places for these people to come. And what they end up doing is parking not only outside of the parking lot, quote unquote lot, they're parking on the street, they're parking on the neighborhood side streets, and neighbors are complaining and this, that, and the other. And so the other thing I learned about this was after I started asking more questions is this happens on the weekends. It happens like if it happened on New Year's Eve-ish, it happened on Christmas Eve, it happened on like Thanksgiving, maybe, I don't know. But the point is it's upsetting a lot of people. So my question is, when we talk about local land use, and we talk about zoning, when we talk about the county process, can we expect these kind of outcomes to happen in the future? Because that's part of what the county's job is, to make sure that there's proper businesses sized properly in the communities that they're serving. It's, I don't want to exaggerate what I'm saying, but it's like locating a Walmart outside of a metropolitan area where there's no room for it. Okay, you can put the 25,000 foot building, but you have no parking for it. It's scalable. I'm not saying it's the same exact thing, but what I'm saying is there's no way in the world that business, if it chooses to stay there, is going to do anything other than really upset the neighbors. So that's my question.
Well, and I'll say the first part is you're exactly proving my point. With a number of licenses added in your county, they won't all have to go there. These are the growing pains that we have because y'all voted for it, we made it legal, there was a demand. So once we start spreading these out in your county and throughout the state, those people won't be making as much money. They won't be near as many cars because you won't have to drive 20 minutes or 30 minutes. You can go right up to your street. So that's the goal, number one. Two, we're allowing people to file in this filing protest based on negative community impact. So, and now mind you, if you want to argue that being too busy is a negative community impact, there's, like I said, there's also growing. They've got to get it from somewhere. I'm very glad that they are not getting it off the street. And I know the licenses will be a problem, but the more licenses you get in that area, because clearly there's a demand. So it's up to Will to make sure that that demand is satiated and it's done so in a safe and effective and prudent manner. So again, that's what we're trying to address here. And you get to always file a protest based on a negative community impact.
Well, I don't want to belabor the point because I'm really not talking about perspective looking forward, although I am, because honestly, counties have planning and zoning. There's different areas that for industrial, for residential, for light commercial, for retail. So, what I'm saying is if this is the example as to what it's going to look like on the Eastern Shore, wherever we locate one of these, we're not thinking about parking. Is there enough parking? These are called EDUs. If there's an existing building that's in the middle of a shopping mall, and yes, it can fit technically the business is selling marijuana, but frankly, it's not matching. It's not matching local decision making, and that's, Mr. Chairman, I understand, but all I'm asking is if we're going to usurp local zoning, the people that know best, and frankly, they got a job to do. Aren't there going to be clashes? Aren't there going to be, and we're not talking about clashes over the things that you're worried about. I'm talking about clashes over traditional and appropriate decisions that zoning authorities make.
But number one, your county gives a UNO, right? And they give a fire certificate, right? Before any building can be operational, right? And I believe the fire, for the fire, you have to have a certain number of parking spaces. That's exactly what they're supposed to have done. Your county, when they gave this UNO out, we're supposed to have done. Now, granted, so let me answer it a better way. Going forward, yes, nobody says your county can't take that into account. They just can't say we're not going to have any dispensaries within a mile or 10,000 feet of a daycare. They can say 500 feet. That can't be the reason. They can say, well, it can't go here because there's no adequate parking. Of course, you can say you're not going to get a use and occupancy permit to even open this kind of business because you don't have the parking space. You don't have enough fire exits. All those things. We're not saying you can't say no. We're just saying you can't use these standards to say no. And you can't, but you can still go in and say this building, and you'll be working with the Maryland Cannabis Administration anyway, because they've got to get all those licenses before they can get their final license. But we don't want them to not get a license because they're 1,000 feet from a school or because they're beside a liquor store, because that's unduly burdensome.
All right. I mean, there are other questions. There is a place for county involvement. I'm hoping.
I know, I'm trying to find it.
We don't lose that.
And again, I'm sure you can get with your committee members. I'm sure we'll have a robust discussion about this a few more times, Chris.
Thank you, Mr. Vice Chair. Mr. Chair, I have a real problem sometimes when I listen to the conversation as it's gone today. We have a one size fits all. I mean, I don't know if you've ever been.
What part is the one size fits all?
Well, when you're starting to talk about distances and what have you, and if you look at my district, I probably have one of the largest geographical districts in the state.
Okay.
It will take me almost 2.5 hours to get from point A to point B. So I don't have these dense centers that you're speaking of where we're going to put them. And I'm a local control guy. I see this as some of the stuff that Chris was talking about. We already do things. If we're going to put a restaurant somewhere, we have adequate public facilities ordinance. We have all that in place. So some of the stuff he's talking about, we're experiencing with our medical right now, where it's overwhelming what these people have been able to do with the parking, the lack of parking, and what they're affecting. Okay, that's not going to change. That's going to be the same way. Now, had we known that this was going to go that way, we would have probably done a different type of study for that. And I just really have issues with the state coming into a county. We've done pretty good without it, and we've tried to keep away from the state's opinion on a lot of things. And I think Queen Anne's County and most of my district has done well with it. And I think I'll have this discussion with it, but I really believe that we really don't think the state needs to be involved in our business. I appreciate what you're doing. You can put the guidelines out there, but I think that our commissioners, they're not full-time. We're not full-time, but they have managed pretty well in most of my county. Like I could pick out little pieces here and there, but I think that's the resistance you're going to see. And I just don't understand the need for state control.
Well, again, I've laid it out. We talked about the liquor stores and what happens when the locals do whatever they want to do with no oversight.
But we had different criteria.
I'm sorry?
We had different criteria.
No, we had no criteria for liquor stores, which is why they're like that.
But I'm saying we have criteria now for stuff like that.
That's right.
And you're putting in state control over my criteria. Had I known.
These are state licenses.
Well, that's fine. But you know what? We have the liquors are local licenses, but still controlled by the state.
But you guys gave away those liquor licenses.
No, we didn't.
Okay.
We didn't.
All right.
Okay. And that's what I'm saying. You're punishing us for maybe again, what you're doing, you're taking other people's problems and making them ours. Good.
Delegate, thank you for the question. I want to clarify some, the
I
distance requirements.
I didn't give you a real good question.
No, the distance requirements are already in statute. The 1,000 feet from another dispensary, 500 feet from schools, parks, libraries, that's in the law now. So the HB 805 actually, as Chair Wilson is proposing to amend it, increases what current law is from 1,000 to 1,500. One, two, it adds places of worship in. So in terms of distance requirements, it's actually giving county municipal governments a little more flexibility when it comes to this. Secondly, it's not that nothing else can be done. It has to be on par with your alcohol zoning. And so there can be changes, but you have to do them together. It can't be singling out this one business.
I get that, but I have infrastructure issues. I mean, we're at limits with our septic and sewer, and already we're built out pretty much on some of those things. And those are the things I think are going to cause us a lot of heartburn. you know, where can I put something like this? I think Kent Island, which would be one of the centers where you'd want to put one of these, they're down to next to nothing. We don't even have room for extra housing right now. We're trying to find ways to be able to grow a little bit, and we don't have that. So I just worry about those things. I mean, I don't have, go ahead.
No, I'm just saying, you know that the potential licensee is going to have to find a location first. Like if there's no room, they're not going to like burn down a building or something. They're going to have to identify a location with the electricity, the size of the building, and all these things. As part of, as a business owner, you've got to get that, right? They're not going to try and wedge themselves in.
But this goes back to something we discussed before. If I am sitting here and I'm Steve's dress shop, let's say, sitting in a mall,
of course,
an area, and I'm sitting down, I'm not making a lot of money, and that owner of that mall sees an opportunity to get a bigger buyer in here, if you will, I'm going to get thrown on.
Okay,
and I don't necessarily appreciate that, but that's okay. But these are the things we run into. We don't have all this space and all this geography to go in there and actually do something. To build another new location, that's very difficult, Mike.
And they might not. You're right. You're right. You know, because what I do like, and you agree, is the free market. And what's going to happen is the person who owns that shop or that area is going to go, you know what? I can make more money with this cannabis than I can with your dress shop. But I would assume you would agree that that's the free market that we support so heavily.
I do support that.
And we want that property owner to be able to do what he wants with his property within the confines of the law.
Yes, for the most part. But we do that same thing with farms, but I understand. Thank you.
You decided to bring a bill to this committee.
All right. It's my fault. I should have gotten into, yeah.
Delegate Harrison.
I'm sorry, I have one more bite and one more question, Mr. Chair, Mr. Sponsor. Mako and MML, I think both with their testimony put in that they were favorable with amendments. And one of the amendments is creating a buffer between residential zoning and cannabis dispensaries. And I think that goes back to some of the concerns that many of the residents that we've heard from have. That not only the inundation with where they may go in the dense areas with liquor stores and vape shops and all of that, but they also don't necessarily want them abutting their residential communities. And so I'm not sure, I'm sure that you saw their written testimony, but would you be amenable to having more conversation about buffers between these dispensaries and residential?
We're going to definitely be working with Mako. We have amendments we're working on. I'll say that, you know, number one, the county's in charge of zoning. If it's a residential area, you know, we're not putting a business in there, right? That's fair.
Abutting.
No question. But y'all drew those lines. But if it was a liquor store, that'd be okay.
Well,
But currently,
again, you're punishing us for the sins of
no,
our
I'm talking about the
fathers.
next one. I'm talking about the next one or the next smoke shop.
But the liquor stores are there and they're not going anywhere.
I got you.
And now we have the opportunity to move them outside of the districts, outside of where they're concentrated.
Yes.
And we appreciate them. We're very grateful.
Uh-huh.
But they may be right next to it may be a strip. And well, this particular, I think, amendment talks about there being a strip and then an alley and then a residential community.
Mm-hmm.
And we could still have something like that, although we don't necessarily have a lot of alleys, but it's the same principle.
And I think also that the amendment will have frustrations like Baltimore City because it's all residential. So where would they go then? You know, the way it is, that would be very, very difficult to do because of, like I said, the city especially. But we're all working with MML and Mako to try and smooth this out. I want to make sure, again, that, you know, obviously, the residents are protected, you know, that this is accessible, but it's still not infringing on people. And I want to say this last, Delegate Harrison, is I mean this for all the constituents you're representing. I get the distrust. That's why I really put this bill in, because I didn't trust people to just do it the right way. Because I kept watching. I started hearing whispers of where they're going to go in certain parts of the state. And I was like, well, these are minority business owners. They're going to die on the vine, or that they were going to be all crushed into certain areas. And I was afraid some of those areas were going to have people look like me. I wanted to make sure I'm not discounting what your constituents are feeling. I'll also tell you, it's $1 million business. It's not something that people go into lightly. And we have a great amount of oversight, but I get it. I understand the distrust. I can't argue that. I talk about the liquor stores, well, just like you do. And it's frustration. So why would you now trust somebody to do right this time? But I want you to know that that was the goal of this bill, to make sure to the best of our abilities that we do right by your constituents, that we don't talk over them, that we don't step over them, and we don't punish them having other individuals who don't live in their community coming to them. I'm trying my best. We're going to work with it. I'll work with you as well. Okay. A lot of people want to be off this committee. Go ahead.
What is the threshold by which MCA will deny a license? How is that going to be designed? We have 24 jurisdictions in Maryland.
That's already happened. You talk about deny a license or deny location?
Deny location, sorry.
So the language that was referenced is a proposed amendment, so it happened today. Those regulations haven't been drafted.
Okay.
So what we initially, sorry, Deli, what we initially did, we have 75 dispensary licenses statewide. They were allocated statewide by population.
Right.
And then now with this amendment, there will be regulations to evaluate the distribution intra jurisdiction. So it hasn't been developed yet.
Okay. So what is the thought process behind developing that though? I mean, you've got 24 jurisdictions. What's the notification process going to be? Some of these jurisdictions have different notification processes of constituencies about these about these locations.
For alcohol?
Sure, about these locations.
So I'm saying, so I was going to ask, so the same way it is for alcohol, before you built a new liquor store, with the same way it's going to be for cannabis. What's the notification process for alcohol in your county?
I would have to ask my county council.
But I'm sure you're saying there is.
Yeah, again, that we're talking local control. I would have to go back and ask my county
and I
council.
bet you they'll have an answer for you. But my point is, and my point would be, is that would be the same notification procedure that's going to be utilized for the dispensaries.
So walk me through this a little bit. So then there would be a pick of a location and a pre-approval of a location. And then what? So people are in uproar. They've got questions. What's the threshold by which it's, I don't know if I'm putting a cart before the horse a little bit, but I'm very, very concerned. We see it all the time about the erosion of county control and influence and the voice of the jurisdictions. What's the notification process? Who does the constituency call? Who do they talk to? What, is it the MCA, and by which, and by that, what is the threshold by which you will set so that you say, you know what, that's just not going to work there. Sorry, it's just not.
Because the communities are saying not in my backyard.
Basically.
Gotcha.
But I mean
that feeds in on itself to where that's how the liquor stores got to be where they are, because everybody said, I'll go buy liquor on the way home, but don't you put it near my home. And then the poor and impoverished are where all the liquor stores end up going, because everybody said, not my backyard. That uproar you're talking about never stopped them from buying liquor, but they don't want it near them. So the people that got punished the most were people that had the smallest voice. So I don't think uproar in itself is going to be enough. Legitimacy, like we just argued, you can write what was it called again? The complaint. You can write a protest. You're going to be able to file a protest based on negative community impact. That's your uproar.
Okay.
And then it will be evaluated. But this is all done. And
So
I want to make
again,
sure the license.
I can explain the
That's
process.
that's my question. Based on that protest, at what point do you say, you know what, this is not?
Setting aside the protests and the new proposed amendments today, because those are things that are not in effect. How does the process work now for licensing? We're anticipating holding a lottery next month.
Right.
And then from there, you would get a conditional license. What is that? It's not a license to operate. It's a license to start going to look for a property, building your team, and then getting local zoning planning approval.
I understand.
And only after that, getting MCA final licensure. So only after the county or municipality, depending on the case, says, yes, this is compliant with the zoning, because there still is local control here. There's established foot distance requirements, but there's still local control that still needs to be demonstrated before a final license is issued. That's the current process. What my understanding of the chair's amendment is, it layers on top of that in that conditional phase. When a business is getting a letter of intent or something for a property, we're evaluating all of the businesses that are in that phase, that conditional license phase, and where they're going, to make sure that they're not concentrated in a certain part of the jurisdiction.
What about space constraints? So I have a semi-rural district, you know, Edgewater's kind of the business district of the area. What about a space constraint? So we've got licenses out there and we have to equally distribute the license. The rest of it's rural. I mean, there's just nothing out there. Fields and, you know, does the MCA come in and say, you know, based on the space constraint, this area is able to have two licensees, and it's a smaller area. They would be within 1,500 feet of each other, but too bad one of these other licensees wants to put a business in here, and based on space constraints, he or she is going to be within 1,500 feet.
A business would not be licensed if they don't receive local planning and zoning approval. Bottom line. So what you just described was a situation where somebody's within the 1,500 feet, which is not permitted. So unless the jurisdiction you're talking about said, we're going to waive that, because they can, in the statute, they can reduce it.
This is kind of a different animal, though. I mean, you know, cannabis and the equitable distribution of licenses throughout the jurisdictions, and this seems like a little bit of a different animal to me, though. As far as making, you know, this is a whole different business.
It is.
Business model. And
But the model we set was again trying to create a standard and some predictability. So to your point, before he gives a license, the county has buy-in. They just can't be overly burdensome with their zoning. What they can't do, and I will say it again, is say, you know, although it was voted and it was made legal, we don't want it in our county, period. So we'll do what we can to zone it out or make it so to diminish it to the point where it cannot succeed. That's why we put these minimum standards in there. They're still working with the county, getting the license and getting the location. They don't just get to pick a location and the county's going, oh God, I guess we have to take it. It has to meet certain requirements.
okay. All right, we'll talk more. Thank you. I appreciate it.
Thank you, Mr. Chair. I think I might have gotten my answer from that back and forth, but I just want to clarify. So at this point, so in Carroll, so we already have a couple of medical dispensaries. So when they had the grand opening of, you know, everybody gets pot, it was like kind of exciting for like, you know, like a couple, really like a long weekend. And then you don't even see people in line. I mean, they were outside and all. It's really, so it kind of goes back to what Steve was saying, is that, you know, every county is a little different. So to this point, did I hear the gentleman from the commission? So right now, is it only the medical dispensaries that have sort of transitioned into? Okay, so now we're going to get to the point where people are going to apply for the licenses in the different jurisdictions.
They already have.
It's already open. Okay. Have there been any undue burden lawsuits started yet with any counties? Have there been complaints thus far?
So there haven't been additional awards yet. So there's an application process that has happened.
Okay.
Review that's been done, and we anticipate holding the lottery for the awards next month. What we have seen is, even with the medical businesses converting, municipal and county officials trying to stop them from selling adult use. So coming in on July 4th weekend and saying, you're not allowed to sell adult use cannabis, and close them down. So there was uncertainty, confusion at the local level as to the parameters of their control. That has continued. And that, I mean, I highlighted that in my initial remarks. A lot of what's in the bill has been uncertainty by local governments as to what they can do, because there's already, you can do reasonable zoning, it can't be unduly burdensome, and here are the distance requirements. And so that's what we've been getting in questions, and the bill tries to clarify that, consistent with the original intent. Your jurisdiction delegate has 2 dispensaries currently, and in the next round is eligible for a maximum of 2 additional awards. So I think it's helpful to also frame that when, you know, to Chair Wilson's point, 6,500 liquor licenses versus 300, it is an apples to oranges in terms of volume and concentration. The state is trying to be really thoughtful in how it spreads out across the state and then within jurisdictions. And we want to be responsive to you all and to local officials as this moves through the process, as this conditional awardees, as people begin to look for locations. We're going to stay in contact. Here's where they're coming. They then need to go to still the local governments to get those approvals. That process stays the same. That's before anyone can sell any cannabis in this new round.
Okay, thank you very much for your answers.
Seeing no questions, this concludes this panel. Next, we have one last favorable witness, Ashley Bagwell.
You're on my side.
Everybody else is right? Go ahead.
Good afternoon, Mr. Vice Chair and members of the committee. I'm Ashley Bagwell here this afternoon on behalf of the Dispensary Association in very strong support of House Bill 805. This is an issue that we've been grappling with since y'all passed House Bill 556 last year. Bottom line, all of the bills and zoning regulations that have been introduced or contemplated at the local level would have created enormous challenges for cannabis licensees, in particular dispensaries. Worst case scenario, there are counties where dispensaries wouldn't even be able to locate, and best case scenario, they would be able to locate there, but they would struggle to be successful. We have consistently advocated for geographically spreading out dispensaries. As the chairman said, that makes it more possible for dispensaries to be successful, but it also increases access to consumers and to medical patients. Access is good for the regulated market. It's bad for the illicit market. For this reason and other reasons, which I won't get into, we urge a favorable vote on House Bill 805.
Thank you. Seeing no further questions, that concludes this panel. Next, we'll go to favorable with amendments. We have Christina Johnson, Bill George, Kevin Canali. I'm sorry. Is it a virtual favorable with amendment or favorable? Patrice Murray is unfavorable. Right. Yep. Okay. Go ahead. Sorry.
Thank you, Mr. Chair and members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in support of the bill with amendments. You have our written testimony and the proposed amendments. So first, I want to say that I agree with much of this conversation. We should not be zoning legal businesses out of existence, and I don't believe any county wants to do that. What counties are doing is responding to constituent concerns. I also agree there's a lot of misinformation out there. All of us in this room understand that this is different. This is not the cannabis of the 60s, right? This is highly regulated. They're more regulated than liquor stores and most other businesses, but a lot of constituents don't yet know that, and they don't understand that. I want to say that MCA, the Maryland Cannabis Administration, has done a fantastic job responding to our constituents and coming to events and symposiums and really making sure that counties understand the rules of the road. One thing I also want to mention is that, yes, some counties have gone beyond what was included in last year's bill in terms of buffers, but that's because the governor's administration reached out and told us we could do that. After last session, they reached out and said, we think there's confusion. We interpret the bill after getting consultation that actually counties can increase the buffer, not just decrease, within reason. So not a mile, but within reason. And they asked us to communicate that to our counties, and we did. And so some counties did go above and beyond what was in last year's bill. That is true. Our amendments want to address the buffers in this bill. We appreciate the sponsor's amendment to move the 1,000-foot buffer up to 1,500. We'd like it to be 2,000. We also, I appreciate the question earlier about residential zoning. I think a reasonable person could agree that a dispensary should not be within 100 feet. That's all we're talking about, 100 feet of a residential property. If my kid's out front playing in the yard, I think it's reasonable to expect that they wouldn't be 100 feet from a cannabis dispensary. So I think we have reasonable amendments. We appreciate your consideration. We look forward to continuing to work with the bill sponsor and with MCA to make sure that we alleviate concerns and confusion and that we can make sure that this industry is implemented across the state in an equitable way. And we'd ask for a favorable report with amendments.
Thank you. Bill George with the Maryland Municipal League here today in support with amendment on House Bill 805. I echo my colleague from the county's perspective on pretty much everything he said. We're partners in local government on this, and we see the state trying to walk a delicate balance between this important policy priority that's been made to legalize this industry, but also retaining some level of local control over an issue that is really best made at the local level. You know, it's really, when you think about it, kind of how these businesses are going to be integrated into the communities that we all represent as, you know, joint constituencies. So to Kevin's point, you know, we've been talking with the Cannabis Administration. They've been fantastic in their outreach and availability. The amendments, we share our approval of what Kevin described in terms of amendments, we have one additional one on here. These amendments are not out of thin air. They're based on feedback from our membership, but also in consultation with the Cannabis Administration. We look forward to continuing the dialogue with you all, as it sounds like that's amenable to this group. The one additional amendment that I'll point out that Kevin didn't talk about has to do with actually growers. A lot of the conversation today has been around dispensaries. Just want to highlight that the bill does address growers. There's a big discrepancy in the cost to the growers to grow outdoors versus indoors. Outdoors is a lot less expensive. And this provision in the bill appears to want to try and incentivize through restricting local zoning over outdoor growers to incentivize more outdoor growers. That seems reasonable and fine. Our amendment just wants to clarify that the provision applies to exclusively outdoor growers, not those that are hybrids. We see that hybrid growers pop up in municipalities due to the more cramped space. So that's where that came from. Thank you very much for your time.
Thank you. Seeing no questions, is Miss Christina Johnson here? All right, we have one in-person unfavorable. That is Abdullah Hijazi. Okay, do we have anybody in the waiting room? Okay, this is a final, well, I'll call him just in case, but Terry Nuridin. You can just tell me no, Caleb. Jana Parker. Jana Parker. I apologize. Sherry James. Michelle Long. I know Miss Mary's here. We'll let her in a second. And then Anthony Dameron. None of those people are in the waiting room? Okay. All right. Miss Mary, go ahead.
Thank you. First, I want to say to the chair, I appreciate his comments, especially the add-ons, but I would be remiss if I did not go on and read my comments. I'm Patrice Murray, a lifelong Maryland resident, and thank you for allowing me to respectfully express my opinions as you consider this legislation. Today, I come in opposition of House Bill 0805. As you will gather, my vote did not count among those in favor of legalizing cannabis. I feel there are enough vices that have been legalized that affect the well-being, not only for our children, for children that are directly exposed to them in their neighborhoods, but those of them who go to school, play scouts, and go to church with them. This means my children and yours. I have to move beyond the fact that as a government governing body, the state legislature did not use its power to stop the legalization of cannabis. And let's get real, call it what it is, marijuana. Because changing the name does not change the outcome. What I must do today is to try to keep it out of my neighborhood. I oppose this bill because, one, on the issue of unduly burden, in my county, appropriate zoning is a requirement. I can't open a dog pound next to a local grocery store, even if we had one. Two, a political subdivision may not impose fees on licensees that are burdensome, nor establish zoning that they feel is unduly burdensome. Yet I cannot have a dog without a license, and I'm required to have it vaccinated. Nor can I drive a truck through Baltimore tunnels carrying certain flammable liquids. My elected representatives cannot even prevent license conversion, which means every smoke, vape, and gas station would sell or could sell marijuana. I'm asking you today to consider my comments for opposition to Bill 0805. Thank you.
Thank you, ma'am. And that's the final witness for today. That concludes this bill hearing, the bill hearings for today. I hope everybody has a great weekend. See you all Tuesday.